To mention criminal motion of 2023 with an application for execution of this product.
Criminal motion.
Having some information of
আচ্ছা, আজকে লিস্টে আছে তার মধ্যে একটা নেই।
no, that is not in the list.
Of 2025, my lord. FMA number 46.
So it must be in the list. It is in the list. It is in the list. Next.
Worship, I am mentioning upon notice for one application in
Notice of
Upon your lordship permission, I am mentioning my matter for inclusion in the list under heading hearing, your lordship.
Have you served notice?
Yes, your lordship.
Your Lordship, on the last occasion, the matter was dismissed for default. I have filed one registration application, Your Lordship. That is I mentioned.
Serve notice and then come. Next.
May I kindly take your lordship's leave for mentioning an application for restoration along with a condonation of delay in FMA 465 of 2020. Grateful, your lordship.
on today's list, item number 1.
Mr. Singh is coming, please. I'm sorry.
Item number 2.
Why is his matters getting mentioned?
No, I'll say, my lord, this is before I start, lordship will kindly pardon me. Why this got mentioned? Because when my lord was having this determination in the year 2022, my lord, this is pertains to that time. What happened? My lord had directed us to directly pay the money directly to the claimants through their bank account. By mistake, we had complied partly. Within 2 weeks, we had deposited before the learned registrar general. The money is lying deposited with my lord's court. Thereafter, my lord, after 2 years, we got the this check. Now the only modification I am praying for, my lord, let them withdraw from here. I also have the original copy, my lord, because otherwise it will be a case of double payment and it will be very complicated, my lord. My lord will kindly come to page 16 once. Mr. Shubhankar Mondol is there. I've spoken to him. He is online.
Page 16.
Page 16, my lord's that ordering portion. Third paragraph. It was a mistake on our part, my lord. By mistake, we did this.
So what do you do?
My lord?
You want extension?
No, we have deposited before the learned registrar general by mistake instead of remitting it to the bank account of the claimants. Let them withdraw from here, my lord. The withdrawal application of the claimants are also there in my lord's file. Let
Which
them
date?
the challan, I don't have a copy, but we deposited, my lord, on. I'm coming to that paragraph.
Where is that application? Which?
We withdrawal application. My application. Oh.
The learned advocate representing the respondent
Yes.
insurance company submitted to have deposited the compensation awarded
Paragraph 5 of my application.
by the judgment dated 12/12/2022 passed by this court in FM 80 bracket MV 106 of 2022 at the office of the Registrar General High Court at Calcutta. The office of the Registrar General High Court at Calcutta is to disburse the deposited amount to the bank accounts of the
Grateful, my lord. Extremely grateful. Shall I give a photocopy of the check that the claimants have handed over to the company?
photocopy of the check deposited at the office of the Registrar General High Court at Calcutta.
No, it was forwarded to the company for compliance. That check. The original I have.
What is that check?
This check, my lord had directed to remit the account directly in the bank account. So for that purpose, after 2 years, they gave us the check. So this is the photocopy of the check. The original I have with me. If my lord,
The check
My lord,
const reflecting the amount of compensation we kept on record.
my lord, my lord, my lord, is it audible? My lord, kindly give a specific time. Already the award was passed on 2022. Now,
so that the money can be transferred to their account. In this account, it has to be transferred because there already been a time lapse and
Then you should be paying added interest also.
that's what I said, my lord. It's a mistake on our part, my lord.
No, why will
gave
they
it us-
suffer due to your mistake?
They gave us the check after 2 years.
Who gave you the
The
check?
claimants. The bank account details were given to us after 2 years. We could not. We complied partly. Within 2 weeks, we by mistake we deposited with the Registrar General.
The compensation as awarded is to be disbursed in favor of the claimants within 2 weeks. Can কি কত নম্বর আছে ওটা disbursed?
Grateful,
Next.
my lord. Deeply obliged.
I'm sorry, my lord. Item 1 only.
Fast.
Item number 1.
But in this case, my lord, pursuant to this honorable court's earlier direction, my lord, the entire award sum has been secured before my lord's court.
Why
Lordship will kindly, my
are
lord,
you
as
seeking
the
them?
instance of my learned friend, it has come up for filing of paper book.
Where is your paper book?
My lord, he will prepare. Direction is being paid for.
And advocate representing the respondent claimant is to file the paper book on the next date of hearing. He submits to have filed across objection being number COT
Duty 116 of 18.
116 of 2018. Let the department
My lord,
the department is the department is directed to place a case record of
my lord, lower
cross
court
objection along with the main appeal on the next date of hearing.
the
Here,
lower court record is required. My lord. This is the case of no insurance policy.
the Register Judicial Service is to call for the TCR from the concerned learned tribunal prior to the next date of
Extremely obliged to your lordship.
hearing. Next date we fixed on 1st of December.
Extremely grateful to God.
Next,
Item number 3.
I am appearing on behalf of the my lord appellant against dismissal. I have come dismissed on the ground for dependency only. Because why? On
this is only to be mentioned, right?
to be mentioned. My lord, today I am filing the paper book.
So
For the respondent.
to
by-
that only, the paper book filed by the learned advocate representing the appellant claimant be kept on record. The learned advocate representing the respondent insurance company is present. Next date we fix on 2nd of December. Next,
Item number 4.
It needs to be made absolute. I am filing the,
state absolute. Where is your affidavit of service?
your lordship, the affidavit of service is not ready yet.
He's appearing today for the
Where is your CAN application? You
Well,
filed
can
it in-
I have filed one CAN application for withdrawal of 60%.
Your lordship, my for that delay condonation has already been condoned by the previous order. Stay application is there in which I am
CAN 3 of 2020.
CAN 3 I have filed, my lord. I'm for the
Can-
claimants, my lord.
You have filed it in a separate court.
CAN 3, my lord. At
The
that time,
department
it has
is
been filed,
directed
my lord,
the
on
state of absolute
Yes, ma'am.
correct. The department is
20
directed to place the
2024, my lord.
record of the CAN application being 3 of 2024 on the next date of hearing. Why is that?
My lord,
Who will prepare the paper book?
my lord, paper book order has already been passed, my lord, on the last occasion.
it will is I have applied for certified copy. Give me some more time, your lordship.
Next date we fix on 1st of December for filing paper book.
This is
Next,
Item 5.
This only one application, that is Malad, the application Malad. Appeal has already been
who is the other side?
The first time appearing.
Oh.
I mean, for playing for intense stay.
Acha. 4 weeks.
Malad 1 week after vacation, because Malad 4 weeks Malad.
Acha, 1 week after vacation. Issue notice. File affidavit of service. Next date 2nd of December.
5th of December.
2nd of December.
Item number 7. Page.
Previous occasion, my lord, I was referring the, my lord, the different provisions. Only 2-3 provisions is remaining left to be placed. And thereafter, I will place, my lord, so far as the judgment is concerned. I will
Who is your other side?
Mr. Gupta is there, my lord.
Continue.
I have placed, my lord, rule 1. These are the different officer definition of the different officers. I am not placing since I have placed it. Then, my lord, I am placing the rule 9.
ये calculate बोलते हैं।
One more book is also. Yes, yes.
Yes, which rule?
Rule 9. Appointment of the officers. The central government may appoint such person as it consider to be suitable as the officers of the force, and their condition of service shall be such as may be provided in the rules made in this behalf by the central government. Then, my lord, kindly take trouble to have a look at section
But
140.
earlier mentioned about rule 9.
Yes, yes. My lord, for the cost of repetition, my lord, the next one is section 141. Central government can make rules. That also been placed. So for the cost of repetition, I am not placing, my lord, once more. Then, my lord, kindly have a look at rule 15.5.
15.5.
Which I have not placed.
Any member of the force.
Yes, my lord. Any member of the force shall be liable to perform any duties in connection with the safeguarding and the security of the border of India, the administration, discipline and the welfare of the force and the such other duties as he may called upon to perform in accordance with any law for the time being in force or any order given in this behalf by the superior officer shall be a lawful command for the purposes of this act. The lawful command, my lord, the command has been defined. My lord, command I am referring to the 1 and 2. An officer appointed to command shall have the power to command over all officers, men, irrespective of the seniority placed under the command. Suppose, my lord, if any officer who is working under my command, might be he is senior to me, but he has to carry out my command. 2A would be applicable in my case. In the contingency, what they are referring to, in the contingency of any officer being unable to exercise the command to which he has been appointed due to any reason, the command shall devolve upon the second in command if one has so appointed. That means, my lord, every time the command would be, my lord, devolved upon the next command in the down in the, my lord, the post in, my lord, down rank. Suppose if the DIG would not be there, in that event, my lord, IG will not perform the duty of a DIG. The commandant will perform the duty of the DIG as an officiating officer. This is the procedure. If the, my lord, assistant commandant would not be there, DC will not come. The inspector below him, who would be the second in command in the unit, he will officiate as an assistant duty of the assistant commandant. This is the procedure. So senior will not the Jew of a junior. Lord, rule 15.5 I have referred and the 16 I have referred. And these are the rule position, my lord, and the controls and direction can be given by the Director General of, my lord, Force that has been mentioned in the section 5. Once again, my lord, for the
Section 5.
Section 5. Control and directions. Control and the directions, the general superintendent's direction and the control of the force shall vest in and be exercised by the central government and the subject thereto, and to the provision of the act and the rules, and the command and the supervision of the force shall vest in an officer to be appointed by the central government as the Director General of the force. So, my lord, command and control and directions would be given. So, in their affidavit in opposition, my lord, two my lord directions has been given. That has been given by the power of the control and the direction. Certain directions has been given that in view of any exigency or in view of any absence, that my lord, the commandant would be
To
authorized.
ask him to go out of the court? আপনি কোর্টের বাইরে যান।
So, my lord, in their affidavit in opposition, two my lord, the directions has been given, 1997 and the 1998. In both the directions in the nature of the executive instruction, and more particularly for the control and the directions given by the Director General. So, in supersession of this, my lord, I have already placed of the 2003 my lord, the structuring, and where my lord, in supersession of the earlier all the directions that would be governed. Then I am placing reliance upon the my lord, the 2-3 judgments, my lord. This is 2008 Supreme Court cases, my lord, online, Calcutta 958. We need online Supreme. My lord,
Yes, wait,
paragraph
paragraph.
23, 24 and 25.
23,
24 and 25.
25.
My lord. 23, my lord. My lord, got it?
Yes.
The question inter alia arises as to whether the authority concerned can compel the radio officer to discharge the function of the SSO as well. The answer is no. It cannot be said that the post commensurate to the status of the writ petitioner. If an officer does not function in a manner expected of him, he will certainly be liable to be prosecuted in accordance with the law. But law certainly does not permit the authority to impose something upon an officer which in effect attempt to bring his status and the position down. In the present case, the writ petitioner and the virtually sought to be relieved. It was open to the authority, it is open to the authority to respond to the same. By no stretch of imagination, it can be said that the two posts, such and such are in any way interlinked. The posts are distinct and the separate. One does not have any direct link with the other. Nature of the duties and the responsibilities assigned, and the salary and the status and the manner of the functioning. All these clearly distinguish one post from the other. The difficulty of the respondent authorities as ventilated by the senior counsel such and such that there is hardly any function for the radio officer, and there is no scope for the proper and the effective utilization of the service of the such and such officer can be well appreciated. It could be that the prompted by the authority concerned to combine the two according to the such and such the best interest of the organization and the writ petitioner organization. This is of course pleasant way of the looking to the controversy, but the response to the present writ petition, this court is called upon to adjudicate the right of the respondent authorities to direct and they compel the radio officer to do the job of the SSO as well. After the due consideration of the all relevant aspect and the material available on record, the court finds it difficult, it is not impossible to brush aside the grievances as ventilated by the present application. There can be two views, that the directions and the order under challenge is veiled attempt on the part of the respondent authority to bring down the status and position of the writ petitioner. The question arises as to whether the writ court can afford to remain a passive or painfully different when such an action is brought to its notice. Is it not the duty on the part of the court to assess as to how far such action on the part of the respondent authorities is just and reasonable? Is it not for this court to ascertain whether the order passes the test of reasonableness, whether it is the fair or reasonable? It cannot be denied that the court has a duty to ensure that the authority exercises its discretion reasonably and certainly in accordance with the law. It is for the said authority to be fair and impartial, and it has the further duty to hold the balance fairly. No doubt, within the bounds of the legal reasonableness, in the area in which deciding authority has the genuinely free discretion, the function of the court, however, is to see that the lawful authority is not abused by unfair treatment. In the fact and the circumstances of the present case, this court of the view that it cannot be just and proper, not fair and reasonable on the part of the respondent authorities to inflict something on the writ petitioner, which virtually attempt to humiliate him by bringing down his status and position. Then, my lord, remarkable decision, my lord, reported in 1987 for SCC 601 P.K. Chinnaswamy. This is holding the field, my lord. Paragraph 4 and 5. You have got it, my lord? Paragraph 4, my lord. In a democratic polity of ours, the bureaucracy works as the pivot for running the administration. So far as the state is concerned, the matter of the policy and the ultimate responsibility for the running the administration is obviously on the apex body, the Council of Ministers and the executive head and the governor. It cannot be lost sight of that the every officer is the trustee in respect of the office he holds and the salary and the other benefits which he draws. He is obliged to render appropriate service to the state. This scheme postulates that every public officer has to given some posting commensurate to his status and the circumstances should be so created that he would be functioning so as to render commensurate service in lieu of the benefit received by him from the state. If an officer does not behave as required of him under the law, he is certainly liable to be punished in accordance with the law, but it would ordinarily not be appropriate to continue an officer against a post and provide no work to him as yet to pay him out of the consolidated fund. It is with the view that we have called upon the respondent government to give the appellant and the proper posting and the exact work from him. Then, my lord, the 5. We direct the respondent government of such and such to give an appropriate posting to the appellant within the 1 month from today. Once he is given such posting, he must be assigned the normal official work to be discharged by him as contemplated under the rules and the procedure in respect of the post appellant is assigned. We hope and trust that the appellant shall be given the proper assignment commensurate to his position to the service, and the state government in its action would exhibit the bias or malafide.
Okay.
My lord.
These two.
So, yes, these are the decisions, my lord. 2 decisions I am relying upon. Apart from this, my lord, I have already filed an application, which, my lord, my learned friend has already used his affidavit in opposition. We have given the reply that bad entry has been made, despite there being a specific
What entry
order.
has been made?
Bad entry has been made in the, my lord, the annual assessment performance report. A successive document I have disclosed. In regard thereto, my lord, because it would be evinced from the document itself, and, my lord, in my application that has been stated. They have not stated so. In open court, my lord, from the bar, my learned friend has already submitted that has been done since, my lord, my client has not complied with the order. Therefore, there is a reflection in all the order. So there is no justification that although there is an interim order passed by the Honorable Court staying the operation of a particular order, which prompted them to pass same order and giving effect to a order which has already been rested by the Honorable Court, that justification is not there. But only, my lord, to that extent that what is my right if somebody intend to downgrade my ranking in the, my lord, annual performance assessment report, then what is my right? My right is if any entry would be made immediately thereafter, I should be notified. It has been stated, my lord, in Devdatta, there is a remarkable decision of the Honorable Supreme Court. So, my lord, I intend to rely upon this decision on the basis of this, my lord, the principle 2008 8 SCC 725. My lord, kindly take trouble to have a look at my application single document, my lord. There is the stand. There are
Which para? of this
Judgment
judgment, 2008 judgment that you've just now placed,
13 to 16 and my lord 16 to 18
13 to 16,
and my lord and 17 and 18.
13 to 18.
13 to 18.
Okay.
My lord, may I be, my lord, bring to your lordship's notice single one document, my lord, of my application, page 21. May I read out for you from the application?
When did you file the application? Can
Can
2?
2, my lord.
No, can 2.
Can 2 of 2022.
Affidavit in opposition. No,
No, my lord. My application.
yes. Which page?
Page 21.
21. Yes.
This is a communication addressed.
Adverse remarks.
Yes. This is a communication, my lord, addressed to my lord, the writ petitioner. Quote, the reply received of the DIG confidential FHQ is under. The subject case has been examined at the headquarter in the detail with the reference to the Honorable High Court order dated 30th of September 2008. The competent authority, after careful consideration of the case, is
After
pleased
the
with-
outcome.
Yes.
So they have not yet decided.
They have not yet decided, but my lord, all the, my lord, my annual performance report, which has already been downgraded, that would be considered, my pay would be considered after the outcome of this matter.
Okay. You have to say anything?
Yes.
So you conclude on the next date. And
My lord, may I be permitted to file my written short notes of argument? My lord?
you haven't yet filed? Then you file on the next date.
We have filed.
You have filed. Uh, At the submission of learned advocate representing the petitioner, the learned advocate representing the respondent VSF is present. Next date be fixed on 24th of November for filing written notes
Right.
by the learned advocate representing the petitioner and final hearing.
Right.
He has already filed the written notes. So on that date, he will finally submit whatever you have to say. You conclude.
I'm grateful.
Next.
But I'm for the state respondents in this matter, my lord. In item number 14, your lordships directed me to appear in this matter, but in spite of several requests, the writ petitioner did not submit the copy of the writ petition till date, my lord.
এটা আর একটা writ petition আছে না? দুটো আছে তো?
Analogous matter, my lord.
Yes. None appeared to represent the petitioner. The learned advocate representing the state respondent is present. Let the matter be adjourned for the day as last chance. Next.
It will appear on, my lord.
Tomorrow, sir, as last chance. No, actor murti. Enter, huh? No, last day. Next.
17.
None appear to represent either of the parties. The matter be dismissed for default. Next.
18 and 19.
18 and 19 কেন হবে একটা তো? Oh, 18 and 19, yes. I have already filed a report.
Yes, sir.
As per your lordship's direction.
What report, sir? What is the report, sir?
It is a writ petition, my lord, filed by them to publish the result. In another writ petition, but the honorable court has been pleased to pass an order. If the employment is cancelled, if the panel is cancelled, intimate them, and your lordship asked me
to file a report to that effect, what steps we have taken. I said, next order.
I'm for the petition.
Report টা পেয়েছেন তো? না। Report পাননি?
Item number 18, I'm for the petition.
দেখি রিপোর্ট আছে কিনা দেখি। হ্যাঁ ও তো রিপোর্ট তো সার্ভিস করতে গেছিল তো দিয়েছে মনে হচ্ছে আপনাকে দিয়েছে রিপোর্ট দেখো এই তো আমরা রিসিভ করেছেন আনারুজ্জামান
ও এই রিপোর্ট নয় তো এটা আচ্ছা ও এইটা Lordship,
You are appearing in which matter?
item number 18, Lordship. Lordship, in this matter, there is a interim order for recruitment. Lordship, they have not mentioned that they have recruited by in the meantime.
Where is the copy of the report, sir?
report I have already filed before your lordship.
Lordship,
Report is
there was an interim order. They have already recruited in the
That's not the
eastern zone in other state, 7 except West Bengal. They are saying that we are taking the outsourcing.
On the earlier occasion, you were not
They have
there.
not mentioned. No, Lordship.
কি বলছেন
Then have you gone
No,
through
no,
the
no.
report filed by them?
I am Aurobindo Mondal, says Food Corporation.
Have
of
you
India.
received the report that the
Lordship, they are
FCI
saying that another matter, Lordship, in the my matter, they are.
Joseph discuss.
Yes. This is the report.
So what is wrong with the report?
Report is that, Lordship, they have not mentioned that whether they have recruited in terms of that notification. There was an interim order of the আমাকে বলতে দিন, there was an interim order of the court, Lordship. They cannot appoint any person without the leave of the court. The 9th seat was vacant for the petitioners, but in the West Bengal they have not recruited for outsourcing. In the eastern zone, the notification was and recruitment was for the eastern zone. They have recruited in the other state, but in terms of that order.
Do you want to file an exception? To
Yes,
this?
Lordship.
File an exception. Let him file an exception.
As your lordship, please.
On the other earlier date, you should have been present. Then by this time, you would have filed the exception.
Lordship.
On the last date, you were not there.
I'm grateful, Lordship.
The learned advocate representing the petitioner. You are appearing for both 18 and 19.
No, I'm for the 18.
But 19 has been disposed of. 19 and order has been passed. Getting there are several deputations on same line.
Okay. 18 এ হবে এটা 18 19 এরকম করে এটা কি নিয়েছিল আপনি না আপনিই তো নিয়েছেন
19 has been record has been called for by your lordship.
না না
See the order and the petition.
The learned advocate representing the petitioner intends to file an exception to the report filed on behalf of the respondent FCI in compliance with the order dated 28/3/2025. Next date be fixed on 13th of November for filing the exception. Thanks.
But if he files, if he serves me a copy 15 days earlier so that I can prepare
A
myself.
copy of the exception is to be served upon the learned advocate representing the respondent FCI a fortnight earlier.
That's okay.
My lord, in this matter, my lord, I have already submitted the written notes of argument. My learned friend also has placed my lord the submission.
Lordship, I am led by Mr. Arijit Majumdar. Praying for not to delay.
No, everything is complete, my lord. Your lordship has kept the matter CAB. Subsequently, my lord, it has fallen from your lordship that certain clarification is required. On previous day, my lord, he has clarified his position.
I had to ask you something. Noted it down. Wait for some time. I just find out.
My lord, may I say, my lord, may I say?
Yes.
The initial issue was.
I know the issue.
No. What your lordship intend to know from me, my lord? that whether subsequently the any other officer has been appointed my choice or not, they are what they are claiming. Actually, nothing was happened. In paper might be mirrored, but in physically nothing was happened. No document was given. Even in the affidavit in opposition, there is no reflection. They intend to make out a third case, whichever directed by Justice Dotto, that you appoint the person of his own choice. I propose 3 names. Subsequently,
No, sir. Another name transpired. I mean,
no, there is no document, Miller. There is no document in the affidavit in opposition,
but
reply,
then
and the writ petition.
you had been given the friend of your choice.
Yes.
Friend of the accused as per your choice. It's not that ultimately you were not granted the friend of your friend, I mean, the friend of accused as per your choice.
May I submit? I propose 3 names.
Hmm.
Subsequently, that has not been initially given. I approach before this court. Court directed, Honorable Court directed that you consider that the suitable person can be appointed or not. There is no document in their affidavit. They did not disclose any document. It was your Lordship's pleasure to produce entire document. They are showing certain documents from their record, which is neither here nor there.
They did not show, sir. The document was asked by the court to explain. The court point, you were not there on the earlier occasion.
Sir, I have been informed by my learned junior
Whatever
that
it is,
since the date has
who
been
had
fixed,
informed you what is not to the knowledge of this court. I had seen certain documents which were.
Might be this is not the part of the entire pleading. Neither
Sir,
the writ petition nor the
taken up the point that you did not receive or you were not assisted by the person.
That would be reflected from the order of dismissal and the
Of your
relevant
choice,
document.
but they had issued an order.
Might be order issuance of the order and engagement of the person is not the same.
But ultimately, you had been given the opportunity.
No, that has not been given. I have taken specific instruction from my client. There is no single document on record. Suppose, my lord, an order has been issued. Subsequently, I have signed it. But the person is required to be appointed. There is an official order that somebody has been detailed.
I had seen it in the evidence itself.
My lord, I don't have any access to the evidence because that nothing has been given to me.
I had seen, and that is why I had asked.
Kindly allow me to inspect the document, which is the document, and refer the document. I will give the reply on the next day. On that score, I have taken specific instruction. For appointment of a person, my consent will not do. There should be an order, official order, appointing someone.
Case record আছে? Huh? ওই রেকর্ডে আমার পয়েন্ট আউট করা আছে। ওই রেকর্ডে আমার See, where's your senior?
Lordship, he is engaged in court number 4. So he's instructed me to.
হ্যাঁ, এখানে মার্ক করে রেখেছিলাম। SSFC proceedings এর মধ্যেই ছিল ওটা। তিনটে ছিল না? এই যে এই তো ওটা। Nishit Upadhyay.
No, never been appointed.
Yes. Was appointed. That is what I asked them. This
Lord,
is
the
the
document
order.
your lordship is referring to.
This is the
It
order.
doesn't have any.
This is the order.
My lord, this copy has not been disclosed in the affidavit in opposition. Kindly give me a copy so that I can take instruction. This is the first time they are disclosing it.
They have not disclosed. What am I telling you? while I was scanning the records, I came across this document. It was not pointed out to the court. Court on its own account uh, fixed it on the earlier date for explanation. It was not pointed out to the court. Neither of the parties pointed out this to the court.
তাড়াতাড়ি দাও না, অর্ডারটা দাও না। I
দেখি
have
ওই
to, I have
order
to
টা
take
ফেরত-
instruction and kindly direct them so that I can get a copy. So that I can give the reply, because this is the document that is subsequently, so far as this document is concerned, subsequently.
That is why I asked you.
I will give the answer, because I will give the answer. Kindly fix a date, convenient to lordship, I will give the answer. That is the 16th of February.
16th of February 2014.
16th of February 2000.
He also could not throw any light on it, and thereafter
May I know
thought-
the name of the person?
Which person?
Your lordship has referred, page what I have seen. Nishit Adhikari.
Nishit Upadhyay.
Nishit.
Nishit Upadhyay.
Well, I will give the reply.
And that too, he had sought for his appointment in Hindi. That also I read as
Well,
okay.
Lordship.
So it's not that
I will give reply.
while I was scanning through the records, I found out.
The lordship noticed this, my lord.
Yes. It's not that he pointed out.
Right.
I noticed and I.
Right.
That is why it got halted in between.
Well. ডেটটা তো পাওয়া যাচ্ছে না মিনিমাম।
Now the case record is with the court. It's kept in the safe custody of the court.
Lordship, may I interject once? Lordship, the point which was urged by my esteemed senior friend on the previous occasion, that has been, I had tried to clarify it on the previous occasion. Is that,
Okay, sir.
Lordship, that the friend of accused, if I may bifurcate the friend of accused into two legs. The first leg, when the initial proceeding was initiated, at that relevant point of time, it is an admitted position that the friend of accused which the petitioner has sought for was not given to him. He filed the writ petition. A stay was granted. The discipline proceeding was stalled. Thereafter, we filed an application for vacating of the interim order. That was taken into consideration by an order dated November 2013, Lordship.
That's all I know, sir.
Lordship. Now the second time when this proceeding started from February 2014, that relevant point of time, by a letter dated, if I'm not so mistaken, Lordship, however, the record's not there.
Have a copy of this record?
Lordship,
You
I
give
do
him
have.
a copy of that order dated 14th of February 2014, it seems.
That record is not there with me, Lordship. That is
in the court.
Is in the court. Lordship, the petitioner, if so desires, he can inspect the records, Lordship.
Inspection, only the procedure is somebody has been appointed.
So
Immediately.
you want a copy of that order?
Yes, my lord.
Lordship, it is not, Lordship, may I subject this?
Wait. SSFC proceedings record ta dekhi, Shantanu?
My lord, may I be permitted to, my lord, go through inspect the record once in his presence?
You can.
I have no objection to that, Lordship.
Then I will not dictate for
No,
direct
this part
any
is not
order to be given to
My
you.
Because, Lordship, one thing, apart from what my esteemed senior friend is submitting, that apart from that particular order of detailment of the friend of
Sir,
accused.
I had certain queries.
Lordship.
Right? Which you also successfully could not satisfy. I asked you to seek clarification. Have you done it?
Lordship, I have, Lordship, on the previous occasion, I have, Lordship, clarified so far in respect of the friend of accused, that first set of friend of accused was not given. The second time when he requested, for whom he requested, we have given this.
Permitted to inspect the case record of the SSFC proceedings in the presence of the learned advocate representing the respondent,
Union of India, Lordship.
Union of India, by the court clerk attached to this court after the court hours. Which date?
Don't fix a particular date, my lord.
Huh?
Well, mutually we will determine that.
To be conveniently stated to the court clerk of this court. Next date we fixed on 21st of November for final hearing. Okay.
Lordship. Lordship. Grateful.
My lord, in this matter, my lord,
We are for the respondents, Lordship.
this
Patience.
matter, my lord, laid by Mr. Shubhish Chana, learned senior advocate, my lord, who is appearing for the petitioner, my lord. This week, my lord, he has some difficulty. If your lordship takes it up next week, any day, my lord, as your lordship pleases.
This month, it won't be possible because there are criminal revisional matters also assigned to this court. I think this hearing was
almost done, my lord.
nearly
Only the
concluded.
judgments, yes, nearly concluded. He wishes to file certain, submit certain judgments
On the
my-
prayer of learned advocate representing the petitioner, let the matter be fixed on 17th of November as last chance.
my-
You complete the hearing. In the meantime, you get sufficient time to prepare the written notes also.
Yes, you have filed, my lord.
You're fine.
Yes, my lord.
No, Lordship, Lordship, we haven't filed yet, Lordship. We'll be
File
filed.
written notes, we have
We'll
filed.
file on the next occasion.
The written notes to be filed by the learned advocate representing the respondent Union of India.
No,
Did
Lordship, NIC.
Insurance, my lord.
NIC,
Insurance,
Lordship,
my
1
lord.
to 8.
Respondent LIC. You assist your senior to prepare the written notes and then file it.
Sure.
You may
And we will get a copy, my lord.
give them a copy also.
Lordship,
Grateful.
obliged.
This is pending since long. Yes, sir.
I'll see your lordship's last order, my lord.
Now, last time they had given a very cryptic information.
Yes.
This today they have placed the report which state that for 24 witnesses have been examined
Yes, my lord.
and 18 witnesses remain to be examined.
My lord. लिखे रखो। My lord, 24 exam, my lord. Yes.
The last witness was examined on 19th of June 2024 before the 3rd of September. On the following date, that is on, so from 19th of June, they had fixed it on 25th of September.
My lord.
Now, they have stated that on the following date, that is on 25th of September 2025, a schedule comprising of consecutive dates of evidence shall be fixed for expeditious disposal of this case.
My lord.
So now if this be the situation,
Look, I'll fix the matter after that, my lord, then, my lord.
that will be done and
lord.
there will be a direction to
Yes, yes. For expeditious hearing, my lord.
I have something to say.
what?
My lord, to get this order which he is getting from this court, apparently looks very good that he is expediting that criminal matter. Lordship, the principle of law that the criminal proceedings in a criminal court and the departmental proceedings in the department can always run together.
Then what has prevented you from proceeding?
There is a stay in the matter, Lordship, so we could not.
When?
If your Lordship can
When was the stay granted?
In 14. In 2014.
Lordship,
2014.
Yes.
Until disposal, it has been, my lord, extended.
It has been recorded in the.
Yes, till disposal.
Which date?
My lord, your lordship kindly takes up.
It is first order on 17th November 2014.
17th?
November 2014.
No, sir. There was no stay till the disposal of the.
Thereafter, my lord, 9 January 2015.
Yes, till the disposal of the petition.
My lord. They have not chooses to file any appeal or, my lord, vacating application.
Yes, it's there till the disposal of.
That's right. So what I want is the lordship, we can expedite.
Wait, the report filed by the Chief Judicial Magistrate, Bankura, through the Registered Judicial Service, High Court of Calcutta, we kept on record. The CJM Bankura is to conclude the recording of the evidence on a day-to-day basis and thereafter dispose of the case number being 36C of 2014 as expeditiously as possible without granting any adjournment to either of the parties. And submit a report of such conclusion of the entire proceedings to this court by 15th of December.
My lord.
Next date we fixed on 15th of December.
My lord.
No, 15th to order volume 18th of December.
My lord.
18th of December, I have given sufficient time to the.
My lord.
25th of September also. তো 15th বলেছি না to 19th December. Next date be fixed on 23rd of December.
Very well. As your lordship.
Yes, they get sufficient time
Yes,
to get it done. A copy of this order be communicated to the Court of CJM, Bankura, to the office of the Registered Judicial Service, High Court at Calcutta. Yes.
I was just, like, sufficient.
If the subsequent order was not there, then I would have asked you to continue.
Yes, lordship, but then.
Since it is there, next.
My lord, in serial number 35 and serial number
36, my lord, there is a direction to file the written notes of argument, my lord. Hearing
This is that matter.
Yes, yes, sir.
my lord, Mr. Monujendra Narayan Rai, he is appearing on behalf of the West Bengal State Election Commission in both the matters. Now, my lord, your lordships must be aware that due to a severe police assault upon him, my lord, his pelvic bone has been broken. And my lord, he is bedridden, my lord. I am praying, my lord, kindly keeps the matter only 1 week after vacation. In the meantime, my lord, we shall.
My lord, last location, Mr. Monujendra Rai.
My lord, we shall file the written notes.
Lordship, when lordship asked him also that would he like to file the written notes of argument, he told in the open court, my lord, that he is not going to file any written notes of argument.
My lord,
and also state respondent also stated the same thing.
You are
My
appearing
lord,
for
My lord,
whom?
I am
2016 matter, my
my
lord.
lord, appearing
Who
with
are you appearing for?
well, for the West Bengal State Election Commission. Well, he is appearing, he is leading in this matter, and I am with him. Now, my lord, this is the difficulty, my lord. He is bedridden, he is sick, my lord, everybody knows, and there was also a strike.
What about
The-
state? Who is appearing?
Both the matters, my lord, Mr. Dey is leading us, my lord, item
Right.
35 and 36.
Did you file any written note?
No.
Chanchu. So I believe you had filed on the other.
I will be filing today, my lord. I am ready.
Then you file it.
My lord, I'll just get it stitched and.
Okay, then on the next date, all of you file.
My lord.
On the prayer of the learned advocate. You are not representing. Did you appear earlier?
I appeared earlier, my lord, with him.
Representing the respondent number?
Well, this is West Bengal State Election Commission.
One. Respondent number one.
Only the West Bengal State Election Commission.
Respondent number one, WBSEC. এটা তুমি লিখেছো তো? Huh? The respondent number one, WBSEC. Let the matter be fixed on
ঠিক আছে 1 2
21st of November. 21st of November.
21st. Grateful.
My lord, kindly record as last chance. Kindly record as last chance.
Sorry?
Kindly record as last chance, my preemptory, my lord. Kindly, 2016, my lord.
Your colleagues.
Yes,
madam.
my lord.
But it is
If on that day nothing happens, then last.
but it is respondents number 1 to 3. Obliged, my lord.
37, my lord, I appear for the petition.
Well, I am for the limit by Mr. Singh, my lord.
Mr. Sen is not appearing.
In the investigation matter, he is appearing, my lord.
In another matter, he did not appear. He had sent somebody else.
In the CSTC matter, he is not appearing.
What is
Because
the
that the
difference?
Command and authority conflict in the some matter.
Where is he?
He is engaged on code number 14.
My lord, the matter is, my lord, ready for hearing, my lord. If I, my lord, file it.
Tell me what is it?
My lord, the petition pardons to my lord, compensation.
You have rejoined to the reporting.
That has been filed.
Okay.
Already filed, my lord.
My lord, compassionate appointment. Issue of compassionate appointment. my lord.
I believe the report said that was no scope.
No scope, Kyle.
No scope for granting
No,
my lord.
compassionate appointment.
My lord,
There is no
subject
scheme,
to
my lord, at
my
all.
lord, subject to lordship's correction, my lord. Initially, when I, my lord, applied, that was not, my lord, intimated. Inspection inquiry was made. My lord, in the inquiry report, they have stated, yes, I am suffering much stringent financial crisis. But after that, they offered that you take a contractual appointment, which I did not respond.
Why? You wanted compassionate, permanent.
Compassionate appointment, my lord. My lord, I rely upon the judgment of the Honorable Apex Court, my lord. My lord, may I file the written notes of argument? My lord, it is, my lord.
Okay. Chanchal. Are you the advocate on record?
Madam.
The learned advocate representing the petitioner intends to file a written note of argument. And the same is allowed. Next date be fixed on 26th of November for filing written notes of argument as well as final hearing.
My lord.
Sir, if Mr. Sen is not there, you will submit.
My lord.
Every day you will come and take the
My
plea of
lord.
Mr.
Lord.
Sen. It
My
will
lord.
not be allowed.
Give down.
Kolkata Court.
Lord, on the last occasion, my lord.
Yes, where is your
It has already been served upon the.
Yes, my lord, it has been served on me.
It is the original matter.
you seem to be never satisfied.
I am, my lord. In this case, I am.
Thank God you are.
In this case, I am. Lord, I do not need to recall the matter, my lord. If your lordship has that photographic.
So then I'll fix it for orders.
My lord,
You are satisfied?
my lord, may hear me for at
Okay.
least. My lord, may kindly take the list of dates my lord, filed by me at one side and the list of dates filed by my learned senior on the other side. My lord, the sole contention, my lord, of the writ petition is that the examinations pertaining to the training of the petitioner was not done in conformity with the appointment letter apropos the schedule mentioned therein. Had the examination been conducted within the stipulated time frame, I would have regularized within 27th of December 2026. Then I would have got the. It was fallen from the Honorable Court that if Lordships finds that examination is not conducted within the time frame and there is any lacuna on the part of the respondent authorities, then I might have some chance. Now, my lord, kindly sees the list of dates filed by me. The first examination, grade 5 examination, it ought to have happened within 6 months from the date of appointment, that is on 16th of October 1998. But it commenced on 9th February 1999 and ended on 9th November 1999. In my list of date, there I have mentioned delay of 116 days. As your lordship found that?
Is this the one?
Fine.
Yours?
I understand that is the one, my lord.
Okay.
Yeah, I have this copy, my lord.
Right, right.
Well, in the last column, delay, with the heading, I have indicated delay of 116 days. Yeah. Now, my lord, kindly sees the list of dates filed by my learned senior. The same examination, the last column under the heading remarks. Past scheduled examination after 12 months, 25 days. However, actual classes for grade 5 commenced with effect from 9th February 1999, delayed by about 4 months. They have admitted 4 months delay. Next, my lord, kindly sees the list of dates filed by my learned senior on behalf of the respondent authorities, serial number 4. Examination serial number 4.
Yes.
Here also, in the remarks side, both examination passed in the first attempt, delay in conducting departmental examination is 4 months. Passed in second attempt, however, second attempt is my lord permitted limits. My lord, serial number 6. Serial number 6, my lord, at
yes,
my lord. On the first attempt, the last column, on the first attempt, the petitioner did not pass the examination. As per the practice, SMPK conducts departmental examination within a month from the date of failing. However, in this case, there has been a delay of 3 months on the part of SMPK admission month. As per the appointment letter, a failing candidate to be called at an interval of first 1 month, first conducted on 10th August, which I refute. In my reply, I have refuted that on that date, though it was scheduled, but no examination was held instead of 6th May. So, my lord, here 3 months.
You mean to say on 10th of August, the examination was not held?
Not held, my lord. I have indicated in my affidavit in reply, my lord, that also. Thereafter, my lord, serial number 7. 7, the last column, my lord. The petitioner ought to be transferred to the Harvard training on 7th June, same as my contention, whereas the petitioner was transferred to the Harvard training on 22nd June. For operational requirement, a delay of 15 days took place on their part. Last point, my lord, point number 8, last column. A delay of 52 days take place, which includes 15 days. So that 15 days is inclusive of 52 days. Due to operational requirement, he did 131 ships as against 75 ships. In the appointment letter, my lord, in the schedule, it was mentioned either that within that time frame, not my lord, and it was or 75 ships I have to complete. I did 131 ships.
So
More than
total
the-
would have been 75.
75.
So you exceeded.
Exceeded. Now, my lord, in my calculation, in my there was a delay of 363 days on the part of the Kolkata Port Trust. Now, if we calculate 4 months plus 4 months plus 3 months, 11 months and 52 days, in my rough calculation, my lord, it is 383 days. So, in effect, the respondent authorities have admitted that it was a delay on their part.
कौन आया? नहीं भैया.
The respondent authorities, in effect, have admitted that there was a delay on their part. However, my lord, my only contention is that I was regularized in the month of January. Had I been regularized in the month of December, only for a month, then, my lord, I would have been regularized. Now, my lord, the impugned order passed by the chairman of the, my lord, SMPK, Shama Prasad Mukherjee Port, Kolkata, it did not say or speak about anything about delay. Now, my lord, in view of this list of dates, or rather the affidavit.
This is not a list of dates. Whatever he has submitted, that
affidavit.
is not without affidavit. The list of dates which he has forwarded, that is
Anyway,
not.
sir, your list of dates or the explanation that you have given.
They have not taken any exception to our
Refuting you.
report, to our report.
They are not refuting you because you exceeded the number.
No.
They claimed 300 and
Well, in our calculation, it's 363 days. delay.
according to them,
According to them,
you said 383 or something.
my lord, 1 minute, my lord, I am just 382 days approximately.
82 days. So they are happy.
We have not said so. That is his contention. I shall explain. I
I have, my lord, read over from the list of dates.
They could have taken exception. That is a order passed by your lordship. They have not taken any exception to our report.
You have filed the report today.
Yes, my lord. Already I have served it long back. There was a direction passed by your lordships.
My lord,
Anyway, sir, you explained it that there was no delay.
My lord, the affidavit, I have read over the delay from the affidavit filed by my learned senior itself. And their contention is supporting my case. Their contention is supporting my case. 4 months plus 4 months plus 3 months, 11 months and 52 days. And in the impugned order of the chairman of the SMPK, it did not speak about their lapses or lacuna on their part, my lord. So, in my humble understanding, my lord, the respondent authorities have admitted that there was a delay on their part, and it is my humble submission before this honorable court, in view of this affidavit filed by the respondent authorities, that, my lord, prayer, kindly seize my prayer, my lord. My lord, prayer B, my lord, at page 39 of my writ petition. Prayer B, my lord, issue rule calling upon the respondent and their main agent and subordinates to show cause as to why the order dated 20th April 2017 passed by the chairman.
Yes.
It shall not be caused, my lord. Then, my lord, prayer C, my lord, directing the respondent authorities such and such bestow the petitioner with the benefits of pay hike with effect from 1st January 2007. Since when the, my lord, the pay revision took place with the other grade, my lord. Prayer D, my lord, thereafter, to prepone and or rectify the date of confirmation of service of the petitioner as a regular pilot with effect from 7th of December. Since, my lord, it has been admitted that I was about to be sent in the harbor training, but due to operational exigencies, I was not, my lord, shifted. And then, my lord, prayer E, my lord, respondent authorities are there meant to pay the arrear and the consequential benefits. So, in view thereof, my lord, the prayers, my lord, that I have indicated be allowed and the impugned order should be quashed. Thereafter, the if your lordship permits me, if the learned friend after my learned senior is concluded, then I would, my lord, like to reply there too. These are my humble submissions.
Yes, my lord. Lordships kindly take my affidavit.
Not today, sir. Not today. For the submission of the learned advocate representing the petitioner, the report in the form of an affidavit filed by the learned advocate representing Kolkata Port Trust in compliance with the order dated 14/5/2025 be kept on record. A copy of the same has been served upon the learned advocate representing the petitioner, who declines to file an exception to the same, having been satisfied with the contentions therein with regard to the number of days delay. Right? Next date, be fixed on 14th of November for the submission of the learned advocates representing the respondent Kolkata Port Trust.
Yes.
Yes, sir.
My lord, I am for the petitioner.
Yes.
I am to be led by Mr. Shomo Mujumdar.
Yes.
And I am seeking an accommodation.
Today, it has been fixed as last chance. Earlier, 3 dates were given.
My lord, that was for the reason of my medical problem.
Yes, sir. You
I'm-
please start. What
Lord,
is the
in fact,
issue?
I'm also not ready. Please, my lord, just a day or two or something like that. I'll be calling Mr. Shomo Mujumdar to come here, and because he'll be leading this case.
You are the advocate on record.
My lord.
You are not aware of the
My lord,
prayer in
it's a
the
transfer brief.
petition.
My lord, it's a transfer brief, and very recently it has come to us, and that was very recently been given
What
to
is your
Mr.
name, sir?
Mujumdar also, Mohammad Baharujjaman.
এই বকালতনামা কোথায় আছে দেখুন? Where is Mr. Mujumdar? He must be there in the court.
I rang him last night, and today I could not get in contact with him. This is my candid submission, my lord.
Go and find out where he is, Mr. Mujumdar.
I'll try to.
He must be there in the court itself. What
Absolutely,
will you
absolutely.
try? Find him out. Ask him to come. Next.
My lord, I am also trying.
Yes.
My lord, I am for petitioner.
On last occasion, I have submitted, the petitioners has been convicted by the CBI special court. The order of the certificate copy of the order we have applied for the authorities.
Have you received it? Have you received that copy?
I have not, certificate copy I have not received, but in plain copy of the order I have. Plain copy, my lord, but I have applied for.
Where is it?
My lord, I am for petitioner.
This my lord, the CBI court's order, and they have applied, they prefer an appeal, but still is pending.
The petitioner has preferred an appeal against this.
Against that.
Against this order of conviction.
Yes, so that is pending.
That is pending. So what is the status here?
Here we have, the persons have been discharged.
Dismissed from service.
Dismissed from service.
So by the next date, you file the certified copy of this order.
My lord, then more time is required. But after vacation, if it is possible.
The learned advocate representing the respondent railways has placed a copy of the order passed in TR number 04 of 2015 whereby the what is the name of the present whereby the present petitioner had been convicted by the Court of Special Judge CBI, Court number 11, Bhubaneswar. The learned advocate representing the respondent CBI is to submit the certified copy of this aforesaid order before the court on the next date of hearing. The learned advocate representing the where's your senior?
He's not come to court. Your treatment for your treatment.
Oh, the learned advocate representing the petitioner is absent. Next date be fixed on 19th of November, sir. Next.
May I take back on my lord? That will get you.
No, it will be kept on record. In case you fail, which I think you can,
We have
so we
already
proceeded
applied,
on this
but
order.
government is not giving early.
Next.
57.
Lord, I am appearing on behalf of the private respondent, respondent number 4 to 6, 8 to 11, and my lord 13. We have already filed our opposition, my lord. My learned friend has not yet filed it. His reply.
Did not, in spite of having your lordship reaction,
What are you saying? You had to file the affidavit in reply.
So for my contention, I am
the private respondent, my lord, private.
You are for the petitioner.
I'm for the petitioner.
So you were supposed to file the affidavit in reply.
Reply for the private respondent only, as due to the physical illness of my client, the petitioner, that he could not come to the court, and I'm ready, my lord. But due to the physical illness.
and also your lordship.
From the ABDB.
Your lordship also please to direct upon the state government as well as the my lord, district judge to file their respective opposition. They did not use
So,
the.
my lord, I am for the state, my lord, and I am for the my lord. Already referred my lord, the promotion was applied in the year of 2015. Now he is seeking for as per the gradation, he was promoted. Now he is seeking for the roster.
Juncture. The registered judicial service is to seek an explanation from the district judge. District and Sessions Judge Dokhin Dinajpur as to why the order dated 4/8/2025 passed by this court to file affidavit in opposition has not been complied with. You had appeared on the last occasion, right? And I had asked you the time to be taken for filing the affidavit in opposition. And what folded hand, sir? If you have failed to prepare, then let the.
My fault, my lord, kindly consider. Normally, my lord, it is not good. I always go with my lord, somehow my lord, for the person. Kindly, my lord. For the last chance, my lord. Kindly, my lord. Kindly. The last chance, my lord.
What is the issue, sir?
Well, the issue is my lord, so far the gradation list has been prepared by the my lord, learned district judge, and it has been made my lord, according to the merits of the list. Well, he is challenging that merit list.
You are for
Well, I am for the respondent number,
private respondent.
private respondent 4 to 6, 8 to 11, and
So
13.
you have been given the benefit out of the gradation list.
Yes. And I have used my opposition, they have to file their reply.
The order was already complied as per the earlier order.
Then why didn't you file the affidavit in opposition?
Yes, my lord. Yes, please, my lord. That's something, yes.
The cutoff. On the prayer of the learned advocate representing the respondent 1, 2, and 3. You are representing? Who is 2?
Learned district and session judge.
So they must be the answering respondent.
Yes.
Respondent number 2. Next date we fixed on 15th of September for filing affidavit in opposition as last chance. Next date, the affidavit in reply to be filed on 15th, on 15th of September by the learned advocate representing the petitioner as last chance. You might not have informed the district judge. You might not have been even got in touch with the district judge. I asked you the time that I had asked you the time that you will take. You told me 4 weeks, and that is how it was fixed today. Next.
My lord, I am for the petitioner 63 and 64. It's same matter. Yes, but one matter. The state advocate filed evidence and opposition. I have received the evidence and opposition. One matter, evidence and opposition reply complete. First matter, second, no evidence and reply order passed. 2021. There are nothing I filled it. Third, 54. Today I have the opposition.
What is your name, sir? You had appeared yesterday. देखिए जाओ. Thought time on the ground of Mr.
But today filed the opposition letter. I have yesterday filed opposition. Today received it. His clerk pushes.
Let the matter go out of the dispute.
After vacation, any case, my lord?
Next. 53. 63, 62, 63, 64. Intake. Let the matter go out of the list. 58.
I am for the union opinion.
None appear to represent the petitioner. Learned advocate. Union of India is present. As কোনো নাম দেবে না
7th November. 27. Yes, sir. For order item number 7.
Here are the FMA. I'll give you 10 minutes time. Take your briefs. But my other side is not. I'll just go forward and
After matter item number 41.
There were allegations against him for non-observance of the banking guidelines and laws. What banking guidelines and laws in the matter of working in a particular branch, I got transferred. After I got transferred, there were certain allegations against me that those things, the loans had become bad. But there were certain allegations as regards closure of loan accounts from the country assets. This is number one. And number two, there were certain debits permitted without permission from the competent. The language is from the competent. Instead, I had got in this branch a long time back. Please furnish me the documents and allow inspection thereof through my defense and number two, please indicate the guidelines of the norms which have been violated. The inquiry officer returns in a very perfunctory manner. Does not discuss the defense case. Holds that all the charges are true. I prefer an appeal, departmental appeal that got rejected, mainly quoting the statements and observations of the inquiry officer and the department and the disciplinary authority without an independent finding returned as regards the appeal. The review application is filed from the appellate jurisdiction within the parameters of the rules. That is also rejected, hence we are before your lordship.
Sir, they had to file affidavit in opposition.
The affidavits has been exchanged, your lordship, but the
File the reply also.
yes, affidavits has been exchanged. We seek to file a written notes in this matter, your lordship, because this is also a change brief appearing in change brief matter, your lordship. Certain facets we have to put before your lordship. We seek to file the written notes in this matter.
In the very limited scope of not jurisdiction in disciplinary matters, I can't invite your lordship to reappraise evidence. Only thing that
Yes, we have filed the Vakalatam. We have appeared on the earlier occasion, your lordship, also.
In the month
Fine.
of November.
As your lordship.
5 Thank
Grateful.
Presenting the respective parties. On the 26th of November for filing written notes on behalf of both the
Parties. Grateful.
for orders. চঞ্চল কোথায় গেল? Monique,
Yes.
will keep it as short.
It's a fatal accident death claim. London Tribunal assess the award of compensation to tune of rupees 73,670. Hello, without following it, without applying any multiplier system. And not granting general damages. And income also.
The age of the victim.
Age of the victim, my lord, as per postmortem report, was put from the investigator of the investigation that he was aged about 50 years at the time of accident. 50. But, my lord, the election identity card, which was produced by my client, as per my lord, the voter identity card, he was aged about 61 years. So, my lord, I am giving the flag mark, my lord, the lower court
CR.
record, lower court record. Yeah.
Accident took place in the year
2006, 20th 11 2006. রিপোর্টটা দেখলাম আছে, চুপ কর। এইমাত্র দেখলাম
Yes, sir. Multiplier method was not applied.
Multiplier method. Lordship, kindly see the my lord, the 7. Lordship, kindly the second mark. This is the postmortem report and the investigator of the
Page 19 of the paper book. Excellent.
I multiplier my lord as per the Pranay Shetty and the Sharara Verma between 60 to 65, 7 multiplier. 5 in the my lord 163.
Multiplier method was applied. How can you say multiplier?
Multiplier my lord applied, my lord, not as per the Sharara Verma Pranay Shetty. The my lord age group.
Pranay Shetty was there in 2006, sir.
My lord, when the my lord the matter, my lord, the Pranay Shetty accident took place in the year 1986, my lord. It was also given, my lord, the retrospective effect. So when your lordship adjudicated the
But when you have come up, you are criticizing the impugned order, then
impugned orders on 3 counts.
you said multiplier method was not applied. That's not the right
My
submission.
lord, the income, my lord, assessed arbitrarily as 20,000. Kindly see the judgment, short judgment.
There is no proof of income, right?
My lord, he was a sweeper and a co-worker of like sweeper in a Salt Lake area. He deposed. Kindly, my lord, my point is, my lord, if your lordship, my lord, age as per the postmortem report, then the future prospects, or as per the my lord, the voter identity card 61, no future prospects, and the multiplier would be 7. So I am calculating, my lord, giving, my lord, your lordship kindly say.
Whatever the tribunal has taken, 61. And multiplier will be in that case
7. My lord, multiplier, the 5 multiplier has been used by the tribunal. It should be, my lord, 7. 60 to 65.
yes.
7.
61 to 67.
And income, my lord, regarding income, my lord, one thing, my lord. Kindly allow me, my lord, 1 minute. My lord, very recent two decisions Supreme Court follows in a case of a coolie in the accident took place 2004. My lord, income of a unskilled laborer would be 4,500. Here income, my lord, as per the, my lord, the 3,000, it should be, my lord, because a sweeper in a Salt Lake area, sweeper cannot be a, my lord, a unskilled laborer. He has some, my lord, knowledge about, my lord. I leave it to your lordship. I leave it to your lordship. At least, my lord, 4,500 following the Ramachandran's case, my lord, which was decided by the Honorable Supreme Court in the year 2011, which was followed by the two Supreme Court very recently in the July 2025. Ramachandran's case in the year 2004, the income of a unskilled laborer can be assessed, my lord, 4,500. So at least 4,500 should be, my lord, assessed. Your lordship, kindly have a look, my lord, one. My lord, Suresh Jadhav,
Malad, your lordship seeing Suresh, Sadik na Suresh Yadav.
Whatever you have.
Yeah, your lord, Sheikh Sadik. Your lordship kindly see, Malad, the paragraph 4. No, paragraph 5. It was decided by the July and another judgment.
Sir, 3,000 multiplier 7.
Malad, your lordship,
Coolie and sweeper are not the same. Okay. Next.
Malad, unskilled mention.
You better go to sleeping.
Why? Shubhankar Mondal is the other set, is online, Your Lordship.
Yes, my lord.
Yes.
Your Lordship, this is the case wherein the appeal has been preferred on the, there's a gratuitous passengers were traveling in the vehicle concerned. This is the vehicle which is used, which has been given license only to use for transport. Here, in the case, in the place of transport, it has been used for transporting passengers. So the insurance policy doesn't cover the same, and our contention before the honorable court is we want the amount to be shifted over, the burden to be shifted over the owner. So the owner to be paid the compensation and not the insurance company herein.
Only this much.
Only this much, Your Lordship.
Show me the evidence.
Yes, Your Lordship. Lordship, the evidence starts. Issue to the DW1 is a page 12 and PW1 is page 11, Your Lordship. Your Lordship, this the PW1 is the Tajmira Bibi, who is the claimant herein, Your Lordship.
Page 12, what are you indicating?
Page 11, page 11.
PW1.
PW1.
Wife of the victim.
Wife of the victim.
Where is the eyewitnesses evidence?
Your
Which
Lordship,
page?
this is there is no eyewitness evidence has been given, Your Lordship. Your Lordship, kindly come to page. There's nothing. No eyewitness, Your Lordship. There's no eyewitness. After page 12 is the evidence given by the insurance company herein. The insurance company has adduced evidence, Your Lordship. Before
Where is the charge sheet?
Lordship, kindly come to page number. After page 14, Your Lordship.
Page?
After page 14, the GM. This is the charge, page 19, Your Lordship. Page 22 is of facts.
Sure. Eyewitness, there's nothing.
No eyewitness. Is not
Government advocate representing the appellant insurance company submitted to have filed the instant appeal exclusively on the ground that the victim had been a gratuitous passenger of the alleged offending vehicle bearing registration number WP 25H/3615. Is it under section 163A?
Yes.
Yes.
And the insurance company was not liable to grant the compensation awarded under section 163A of the Vehicles Act. Hence, foreign policy did not mention liability towards gratuitous.
Your worship, kindly come to page 31, wherein the certificate says seating capacity 2 including driver. Page 31.
Learned advocate presenting the referred document marked as Exhibit 8 being the certificate of fitness, which provided seating arrangement for how many passengers?
2 passengers.
Passengers, including the driver.
Including driver.
However, in the instant case, the number of passengers exceeded
More than 10. Yeah, in the chart sheet, it says 10 passengers are traveling together.
extent of nearly 9 passengers. Exceeded two to the extent of 9 passengers approximately as mentioned in the touch or violation of the terms and conditions of the insurance policy, the appellant insurance company was not liable to compensate claimants complying the order passed by the such and such. The learned advocate submitted the learned tribunal to have taken each and every aspect into consideration and further granted the compensation. It's further submitted that the issue of gratuitous passenger was not agitated by the learned advocate representing the appellant insurance company before the tribunal. The contradictions of the terms and conditions of the insurance policy is not controverted through cross-examination of the prosecution witnesses. Good stuff. The since nothing to since an application under section 163A of the ND Act does not accord concept of fault liability. Offending vehicle being occupied by more than 2 passengers not taken before the learned tribunal. Of a notification and this and that entitled to 5 lakhs. 5 lakhs was 5 lakhs.
Yes.
Yes.
Your worship, the other part that we have got an opportunity to recover, that should remain. As there's no court, they have not filed any appeal, cross appeal, so that should remain. In the ordering portion, we have been given opportunity to recover the same. That should remain, Your worship. The OP.
That you did not say. Then I would have made it shorter.
Ordering portion, 3rd paragraph.
Liberty granted to the appellant insurance company to recover the awarded amount if it is found just as directed
Not to push.
judgment and order is not interfered with.
Bharashwat.
Next. Next.
ডিপোজিট কত করেছি দেবো ডিপোজিট কত করেছি 11
261 is yours.
And another payment report.
just 2 minutes.
You file any cross objection?
No, Lordship, the case is filed by the insurance company. On that score, the other vehicle also involved. They are not party in the proceedings. So their contention is that the accident took place due to the another vehicle. Accordingly, they have also filed one application for order 1 that has been rejected by the land tribunal. But here, Lordship kindly says that report has come, whereupon Lordship will found that the evidence copy not with me at the time of filing of the paperwork. But also, but the one of the employee, that is the employee of the insurance company, legal manager, has come before the landed tribunal. They did not take that plea. But you kindly see the lower court here, whereupon Lordship will found that they did not taking the plea before the landed tribunal. So
Why have you filed this appeal?
Your Lordship, the appeal has been filed on the ground
Evidence of
Your Lordship.
exhibit mark
On number 8, Your Lordship, which says contributory negligence point has been taken, Your Lordship, in this case, wherein the vehicle concerned has dashed the vehicle due to rash and negligent driving of a Maruti driver, and therefore the insurance company owner, the vehicle very number, is so liable to pay the compensation to the claimant. And the
So
There's
this
two
the
cars.
tribunal has explained it in page number 61.
Yes, Your Lordship. Yes, Your Lordship. And Lordship, kindly come to the charge sheet. The charge sheet is
Charge sheet has been mentioned.
charge sheet has been filed against the only offending vehicle.
only offending vehicle. So, Your Lordship, page
No.
34. Lordship will find
This ground? Only this ground?
only this ground, Your Lordship. One
Other part, the quantum part, that will remain. I am not challenged, so it will remain.
problem. Your Lordship, but one thing in the chart sheet, the reflection of the Maruti car is there. In the facts, it has been given that the standing car is the truck, wherein the Maruti car has dashed.
Nobody has given that evidence.
No, but in the chart sheet is there. Your Lordship. That's the only.
I did not go to the charge sheet. বললাম তো।
আমি কাগজে লিখে দিতে।
Equal proportion of the time. So there is three claimants, equal proportion and accurate. Accurate kind. That's what is very important.
What?
Accurate there.
Active interest. Next. You people don't get. No, you are the one who deposits. Mr. Mondal, if that word, if the phrase sentence full test it. 262, 66.
262. I'm appearing on behalf of the appellant, and 263 is my learned friend's cross appeal. My lord, remember?
6,000, 4th
Yes.
October 2012, interest 7.5, DL, form number 54.
My lord. Yes, and only regarding that, this is a case of composite negligence. I've given the typed copy of the chart sheet. It's there in my lord's file, my lord. There were total 3 vehicles were involved. Chart sheet was filed against the drivers of 2 vehicles. So I'm praying, my lord, for that liberty to recover from the insurer of the other vehicle. My lord had asked for the judgment, my lord.
Now tell me what did the tribunal consider?
Tribunal directed the insurance company of this Tata 407, that is my company, to pay. I'm sorry, this lorry to pay. Lorry
Who is
only. Only lorry, only my insurance company to pay.
You are for the lorry.
Lorry.
Only one vehicle has been made part.
The observation of the learned tribunal, it's at page 23 of the paper book.
You have given, you are relying on this.
Yes. No, my lord had, my lord had asked for these judgments, my lord, for the proportion.
Yes. Show me the evidence.
My lord.
Eyewitness.
My lord will kindly come to page 23 once. So I'll come to the evidence of eyewitness first. Page 12, my lord. The relevant portion is at page 14, the cross-examination.
Who is in page 11?
Self. Page 11 is self, my lord.
That is
from hospital, Dishan hospital. Yes, medical team.
Page 14, my lord. Cross-examination. The accident took place on 4th of October 2012 at about 11 p.m. I was standing near the race ground at KP Road.
Wait, madam.
I'm sorry.
Now the two vehicles were involved.
My lord.
The number of the vehicles were 6453 and
That is my vehicle.
and
The other is the victim vehicle, wherein victim was in which victim was traveling as a passenger.
but then only the number of the vehicles have been mentioned. The role has not been mentioned.
Last four digit has been mentioned. Last four digit has been mentioned.
Yes,
The chart
you
sheet-
can identify the vehicles by the numbers.
Yes, it's there in the chart sheet. The typed copy is before, my lord.
So chart sheet also does.
The numbers are there.
Numbers are there, but
And the drivers, both the drivers were chart sheeted. Shiraz Khan and Ravindra Kumar Singh. And the papers were seized.
the other insurance company has been made party.
No.
Has not been made party. My lord,
That is why I'm praying for my lords.
supposed negligence, one of the vehicle has been made party. And my lord, other my lord, your losses can produce this to latest instance. 2025 volume 2 PSE 459 my lord. This is last one.
There's another case of canine.
Yes, yes,
case.
yes.
Affirmation my lord,
Probably the judgment is there in.
yes.
আচ্ছা দিয়েছি বোধহয় কে নেই
And also I have also my lord,
But today you have not given that to.
No, on the last day.
It's in the record.
কে নেই জাজমেন্ট একটা দাও
তিনটের মধ্যে নেই
এই যে আছে আছে উনি দিচ্ছেন আরো
yes my lord, can you paragraph 18. But page 16.
How can this be applicable to this case? But here it has already been assessed. It was the role of both the vehicles have been mentioned. But here there is no role.
My lord is referring to Minu Mittal.
Minu Mittal and others.
Then my lord,
How can that?
my lord, brother, he provided me with
Fair enough. I only told you. Yes, he's a good researcher.
Yes, yes, yes.
Did you take this plea before the tribunal?
I'm coming. Paragraph 2, my lord, page 6.
No, you come to page 24.
Yes. Accordingly, that paragraph, my lord.
Charge sheet was not.
No, it was not exhibited.
Then.
But FIR says, eyewitness says.
FIR.
Eyewitness says, my lord, PW2 at page 12 that 2 vehicles were involved.
Vehicles were involved.
Now,
but
what I'm trying to say, my lord.
Vehicle was at fault. That has not been mentioned.
what happened, this accident, my lord. uh,
You can claim that only on the basis of the charge sheet. Now, the charge sheet has not been exhibited.
It has not been exhibited. Yes, true.
No.
It it was a head-on collision, if I'm not wrong.
Where it is mentioned.
No, that is not there.
Not mentioned.
Yes, that is not there.
Before the tribunal can get the charge sheet exhibited.
Well, that can be here, my lord. If certified copy has been filed, according to you also knows that according to section 77.
Wait.
Yes.
All of these judgments are on head-on collision. But here,
In Sobita Guroi, my lord, there is a my lord, direction was there, my lord, to sue separately. Our High Court decision, my lord.
here
Yes,
there
there
was
are
a
two
head-on
vehicles. Yes,
the
two vehicles
charge
were
sheet
there.
was there.
Yes, charge sheet was there.
Everywhere you can apply.
The two vehicles were there.
File an affidavit
My lord.
to seek the charge, file the certified copy of the charge.
এখানে জমা করে দাও।
My lord, I shall.
No.
Mr. Mondal, you want to take back the judgments?
No, no, kindly keep it.
There are-
Yes, yes.
Next.
But this is my appeal.
Seems you have connived today in preparation of the list. How come your matters are there on top?
Because most of this I don't have any matters. That's it.
Something fishy.
No, no, no.
আমার next matter আছে
আর আছে?
তোমারটা আছে
আমারই তো এই চলো।
What these, Mr. Ganguly and Mr. Roy? Something very suspicious.
Your Lordship, he's busy in some other court. Kindly give it a short pass over. I have been said he is in some other court.
Who is he?
No Bandopathyay. He's here only.
26, 20, 265, 266.
Okay.
So there are two insurance companies. I'm for the other insurance.
Appeal filed by the Bajaj Alliance Insurance Company, the Mr. Ganguly, on that score that I have in the case under 168, the Landed Tribunal assessed the compensation by considering the monthly 6,000 per month. So against the observation of Landed Tribunal, he has preferred an appeal. So Lordship, I have also filed a cross objection. There is two insurance company, National and Bajaj. Mr. Singh appeal for the National Insurance Company, we are satisfied the award. So against that Lordship, I have also filed a cross objection. So according to the Lordship Supreme Court judgment.
Under section 163A. Then what remains? How much have you paid?
Lordship, his part, Mr. Singh paid. That the award passed by the Landed Tribunal only from appeal. Okay.
My lord, 163A, 2,94,000 was passed equally, equally proportion between two insurance companies. My lord, my client, one of the insurance company has paid its share of 50%. Mr.
Sorry?
My lord, he has preferred an appeal. He says, my lord, this award was excessive. And my learned friend, Mr. for claimant, has said that award is, my lord, required to go up to 5 lakhs of rupees.
Okay, Chanchal.
in that way, claim cases would not be taken up to. Lordship, no.
No.
Lordship, yeah, I was just getting confirmation because we don't have to bring the brief, my lord, because again, my lord, tomorrow again, my lord, then. Lordship, we will come back at 2 o'clock.
এই যে করে দিল
করেছিল না?
Item 25.
5 and 266
I'll just say.
এটা হ্যাঁ ঠিক আছে
Showed you not the page number 69.
Huh.
But that's I couldn't make your I misinterpreted Milord. I'll just indicate to your lordship Milord, where I went wrong. Bajaj of Mr. Ganguly's clan.
Yes.
Milord, page 59 showed your lordship Milord, the ground number 5.
Yes.
Milord, he said that Milord, the policy was approved March 2012, accident on May 2012. So on the date of accident, Milord, the policy was not valid. Because policy was up to March 12. This is what the ground of appeal is. This is what his contention is. This account is not in would come. But Milord, but this plea.
But sir, you come to page 42.
Page 42. Lordship.
Now, the coverage was 13th of May 2011. Page 42.
Lordship. Milord, this is of no, this is of national. He's for Bajaj.
He's for Bajaj. So
That's what I was telling you, Lordship. Milord.
then Bajaj is a insurance policy.
No policy exhibited and Milord, no arguments made. Therefore, his contention that on the date of accident the policy was not valid, Milord, it is only here, is on this round of appeal and in written statement and nowhere else. Because the award of plenary tribunal does not reflect that this point was ever raised. And no evidence laid, policy was not exhibited.
Policy was not exhibited.
No, that policy is not. Right.
You did not place the insurance policy.
We did not place, they also didn't exhibited the total document, but from the documents it's clear, Lordship, kindly come to the paper book first. Your Lordship, in the paper book, in the petition, claim petition which has been filed before the learned lower court by the petitioner herein, it states in page number 3, Your Lordship. Bajaj Allianz General Insurance Company Limited for Malda Branch policy so and so valid up to 7/3/12.
So it has been mentioned.
It's the admission from the petitioners itself. Now I will prove from the other exhibited documents. Let me submit.
Wait.
Let me submit. Then you will submit. Now your Lordship will find that in the Caesar list has been, which they have produced a Caesar list. My learned senior friend has not annexed all the Caesar list which has been exhibited. Now LCR has, yes, TCR has. TCR page number 49, Your Lordship.
এসিটা চলছে না
Your Lordship, the
page number
49 of the TCR.
49 of which file? You
Of
must
the
not be
main
knowing.
TCR, Your Lordship, the LCR records. It's
Exhibits.
In the exhibits, Your Lordship. Page 49 of
49.
exhibit number 3. It's
Exhibit number 3.
3.
Page 49.
There's a running page 40 and the top of the all the pages, Your Lordship. Top is a running page. 49.
Now, what is the number of your vehicle?
My vehicle number, Your Lordship, kindly come to the
Will
Caesar
you
list.
please tell me the number?
Yes, I'm coming, Your Lordship. My vehicle number is WB 591819.
59A 1819.
1819.
It has been seized under the charge sheet.
Yes, there is a Caesar list.
Then
In the Caesar list, last Caesar list, Your Lordship, will find the Caesar list dated 6/5/12, wherein it has been mentioned categorically that the Bajaj policy is that there's a mark by the pen the judge has marked.
I
Also.
submitted detailed report opinion towards said vehicle such and such. All policy holder Narayan Shaha.
Maybe, Your Lordship.
WB 59A 1819 to
A policy is valid till 7, the same date. So, Your Lordship, there are two things is coming out. Your Lordship.
Partial conduct. Okay. Acha.
And now, Your Lordship, I will show my written statement, page 5.
Acha. It is valid up till 7th of March 2012.
Yes, and the accident is May 2012. So this is another document. Now, Your Lordship, kindly come to my written statement from the paper book. Page 5. This is a fit case to be remanded back. I will show you why. I will satisfy Your Lordship, then Your Lordship pass any order.
Remanded?
Page 5 of my page 5 of the paper book, Your Lordship. My paper book. The written statement filed by the Bajaj Alliance. My written statement, paragraph number 4. Categorically, this averment has been taken, Your Lordship.
You did not appear before the trial court?
No,
You appeared?
everyone has appeared. Everyone has appeared, Your Lordship. Now I will take to judgment as well. This is the my third contention. Now I will take Your Lordship to the judgment also.
Accident took place on 15th of no,
16th of May. 6th of May 2012.
2012.
12.
Now, whether there has been a renewal of the policy or not?
No renewal of the policy. And the most important thing, Your Lordship.
No, you did not prove that before the court.
Your Lordship, they have also not proved my policy.
It is your
They have not
task or
exhibited my
somebody
policy.
else's.
They have not exhibited my policy before the London Lower Court. They have to exhibit to
But
get
the
the
Caesar list.
Caesar list there, but Caesar list is there. But in the when the insurance policy needs to be exhibited, national's policy has been exhibited as it is in valid condition. My policy has not been exhibited. So first you have to prove your case. So you have to first prove your case. You haven't proved your case, so you're not going to get the claim.
Now, the tribunal had asked them to pay how much?
Not 50% of 2,94,000. That is not 1,40,000. 1,47,000.
Okay.
Now, one portion. Page 54 of the paper book. 1 second, Your Lordship. Your Lordship, the last paragraph from the Caesar list.
I have seen it.
Yes, Your Lordship. That's so it's.
Let me first dictate.
Dictate.
You will get all your answers.
But Your Lordship, I bow down before Lordship for every matter. But this matter is a fit case to be reverned back to the London Lower Court. Policy was not valid, and they couldn't prove beyond doubt that the policy was there. The renewal, there's something. No documents are in record, and I have showed Your Lordship the categorical observation in the.
Where is your cross objection? Cross examination?
The cross. Your Lordship.
Did not appear at all.
No, we appeared. We filed a statement.
Yes, we did not file a
Nothing.
Nothing.
But also they are admitted fact. They have admitted. It's not that we are claiming we are proving something new. They have admitted in it.
Cross examination on behalf of OP number 5. Who was OP number 5?
Maybe the Bajaj Alliance.
Number 5 was Bajaj.
Bajaj Alliance. Lordship, as per to judgment, we are OP number 4.
OP number 4.
We are OP number 4 and National is OP number 3.
Is OP number 2. Oh, sorry, OP number 5.
OP number 5, Lordship, one of the eyewitness. Eyewitness, I saw my own
OP
assessment.
number 5 cable. It is OP number 5 cable.
Come to page 30 and 31.
Yes, 30, page 30.
Cross examination of behalf of OP number 4.
That is the Bajaj.
Bajaj.
Then
They did not adduce any evidence.
We have cross-examined, but
not on the issue.
এটাই হবে।
here, during your cross-examination, you did not mention anywhere that your policy coverage was
Nothing.
because they have admitted, your lordship, from the first day they have admitted. From the in the petition they have stated that the policy is valid up to so and so date. So it is in the petition which they have filed before the learned lower court. So they have filed and they.
being the claimants will not be in a position
Your lordship,
to tell
this is drafted by an advocate.
sir, how can the claimants say about the date of policy being issued by you? It's a transaction between you and the owner.
Yes, your
So
lordship.
the claimants would not be in a position. So if you are claiming that the period of policy exceeded, expired prior to the accident, so you had to adduce evidence.
That I bowed on. For that I am humbly praying for a remand. I'm praying for kindly. I'm not praying to. I'm not praying.
Best be given a right to recover from the owner of the vehicle on strict proof. Nothing else. You have sufficient evidence on record.
Whatever funds for.
Delaying the issue.
Of the claimant,
Of the claimant.
lordship.
He did not have, under any circumstances, gathered the information as to whether the policy had been renewed or not.
Lordship.
Turn it up.
Lordship, can the tribunal granted interest from the date of evidence, the 7/2/2018?
Please take care of him. I have.
Lordship, kindly consider this one. On one line, because the tribunal awarded interest from the date of filing the evidence, not from the date of filing. Can you kindly see that page 56? That
Lord, he wants, Lord,
In Next.
I will bless the
Lordship, the previous one, which has been passed. The previous one, just the previous one. Yeah.
Matter. He has to. Very short.
I am very short. Here the policy. Here the license was not valid of the driver. The driver of the vehicle was not valid at the time of the accident, Your Lordship, and that's why there's a LCR has been called for. Certain documents were not there in the paper book. That's why LCR has been called for.
Now, what do you want to prove? Now, did you prove that the DL was not valid?
Yes.
Which page?
Lordship, kindly first I will show it from the judgment. There is the RTO has come also. The RTO has come in this matter. पेपर को कागज पर কোন কাগজটা আরে আপনারটা কোথায় আপনারটা নিয়ে আসুন
What is the name of the owner of the vehicle?
The owner's name is Monisha Horde. Vehicle owner name is Monisha Horde.
Charge sheet is in which page?
Roship, kindly come to page number.
Why just?
54. 54. 54টা কোথায় 54 চার্জশিট বলেছেন চার্জশিটটা আছে 53 starting from page 53. The evidence is in page 22 of the RTO.
Why have you come?
DL is not valid. So owners for recovery.
Evidence. Now
Evidence is on page 22. Paper book.
The matters have been no, there's no possibility of existence of any other data. The extract of the
Exhibits are there, Your Lordship.
set
OPW1 exhibits.
above mentioned license was issued in the name of Uttam Roy.
Yes.
Now, what is the name of the owner of the vehicle?
Owner of the vehicle was Monisha Horde. Lordship, The exhibited documents has to be seen. The exhibit A, B, and C.
This is vague. Cross-examination is absolutely vague.
Your Lordship, the exhibited documents are there, Your Lordship. Exhibited documents are there. Exhibit.
I mean, you just feel like fighting appeals.
The exhibit says that it's not valid at the time of the accident. Your you kindly see the exhibits.
Which
Extract. Exhibit B, but given by OPW1. Exhibit B given by OPW1.
You had taken this point before the tribunal?
Yes.
Did the tribunal say?
Tribunal says it will kindly come to the judgment, Your Lordship. The judgment, page 33. Decisions and findings. This may. The court has gone to the extent of fake license case. Though it's not a case of fake license, it is a case of the driving license was not valid at the time of accident.
Why, if the driving license was issued in the name of another person?
That has been proved that the driving license was there, but it was not valid at the time of the accident. That's the case, Your Lordship.
The driving license is in the name of one Gautam Roy.
Yeah, this is a driver. The owner is different. A driver could be different. Owner could be different.
Driver was arrested. Gautam Roy was arrested.
His charge sheet. Kindly come to the charge sheet then, Your Lordship. 53. Kindly come to 53, Your Lordship. Column 12. Gautam Roy's name is appearing, Your Lordship.
Particulars of the accused persons.
Owner of the vehicle was Monisha Hore.
Monisha Hore.
Why have you come? Pay and recover.
Yeah, nothing.
You could not prove.
Huh?
Could not prove it to be invalid.
Well, the RTO has come, Your Lordship. RTO person has come for evidence.
What did the RTO say? Tell me.
The extract is there. My contention, I know whatever falling from Your Lordship. The original extract of driving license is there. That has been proved. That was not valid at the time of the accident. So at least I should get.
That is not mentioned anywhere.
The driving license proves that. Your Lordship, exhibit from the extract of the exhibit from the OPW1. OPW1, there is
I have
three
seen. I want to see the exhibit. Which
exhibits.
page?
I don't have in the paper book. Exhibits are not there. That has to be seen from the LCR. That's why the LCR has been called for. Your Lordship was not satisfied in the previous occurrence. Said the LCR, I need to see the exact document first.
Exhibit A series. Then the
Lordship, date of accident is 30/11/2011. 33/2011. Mar
33.
30th March 2011.
Oh, good. So from which date to which date it was valid? Further, whether it was renewed, nothing has been written. Valid from 1995 till 1998.
It was not valid at time of the accident. That's our contention. And this is the record which has come from the licensing authority. If it's renewed also, they would have come.
Learned advocate representing the appellant insurance company submitted to have filed instant appeal exclusively on the ground that on the date of occurrence of the accident on
30th March 2011.
30th March 2000. And then he said that once I had given that number, it came again. I mean, in the cross examination, it came with a different number. Next. 267.
I'm appearing on behalf of the appellant insurance company. I've taken 4 grounds. Uh, Very small. One is income, then consortium, interest, and delayed lodging of first information report. Income, it's an accident of 2021. Income, consortium, interest, and non-involvement. Income, it's an accident of 2021. The tribunal, the claimants alleged that they stated that the victim was a auto driver, and the tribunal.
Mr. Ganguly, you write down the amount that you had paid.
The learned tribunal, my lord, took the income to be 9,000 per month.
Job of the victim.
The claimant stated that he was an auto driver, auto rickshaw driver.
The owner of the auto rickshaw.
He was an owner of the auto rickshaw. Consortium, it should be 44,000. A total of rupees 88,000 was granted. It should come down to 44,000.
44,000?
For the widow, total 88 was granted. It should come down to 40. My lord, the widow and minor daughters. And interest, my lord, 4% was directed to be paid from the date of filing. Within 2 months in default, my lord.
How many days delay?
Accident is of 25th of January and the 2021, and this written complaint was lodged on 19th of February. So 25th, 6 days and 19 days. 19 days. 25 days.
Now you tell me
The pages.
Srimanta.
Did a total sum of rupees 6%. Wherein my lord has held that since the that paragraph, since there are certain factors which are not in dispute, that one particular paragraph my lord adds only that involvement of the vehicle, that word should not be there in those in some of the matters. My lord's usual paragraph, my lord, wherein my lord states that since the involvement and all those, that involvement portion should not. My lord, grateful, my lord.
Grateful.
I'm the other. 268. I'm appearing on behalf of the appellant insurance company. I've taken two grounds, my lord. One is this income tax. It was not deducted. Income tax and professional tax was not deducted. And the other is, my lord, there were total income tax and professional tax was not deducted.
Round 6.
And the other being, my lord, that personal deduction.
Where is that document?
I'm coming to that.
This is one.
This is one, and the other is the.
Should be 1/3.
To bole de. The claimants are the widow, minor son, and parents. So I've prayed for that deduction of one third in absence of any proof of dependency of the father on the income of the son. 1/4 was deducted.
Yes, sir.
So for that part is concerned, ground 6 reduction. I don't have any objection. So for the
ground 6 deduction?
Ground 6 of the memo of appeal, income tax. It has been stated in page 34, but ground 6, Roman 6.
Who is PW1?
PW1 is the widow.
11 and 12.
Page 18, my lord will kindly come to. That is from the employer.
PW1 is the widow.
Widow.
Who is the eyewitness? PW3 says I'm not the eyewitness.
PW3
in the cross-examination?
In the cross-examination?
Yes,
Page
Bishwanath
17.
Ghosh, page 15.
Page 15. That is the father of the victim.
Father of the
PW2.
This is a document number 4. Now, page 17, what does this mean? I have deposed in 3 cases approximately as witness of the same nature. What does that mean? The tribunal took this into account?
No.
You also have not taken this ground.
Why I have not taken this ground? Because the FIR, my lord, it was lodged on the very same day. So
And if this person be the father nowhere stated
This is
be
PW
dependent on
3.
the
This is the eyewitness 3.
Vishwanath Ghosh, you said is the father.
Yes, yes.
So father in the cross objection never mentioned that, or in the examination in chief. Did he mention in the examination in chief that he was dependent?
No,
on
that
the
is not
earning
there.
of the?
He has another son who is a cultivator, page 15.
Yes, sir. Yes, madam. In
Yes.
page 14,
Yes.
he has mentioned Vishwanath Ghosh in page 14,
Yes, sir.
paragraph 4, that my son was in service under such and such, and at the period of the accident, my son was posted at South. He used to earn great salary, and my son was sole earning whatever of my family. I and my minor and my daughter-in-law, all the petitions were solely dependent, and this was not refuted or controverted in the cross objection. Chanchal.
It's not that much legible. Page 66, my lord, will see. The,
I have got a legible copy.
You did that for income tax and the professional.
yes, I shall. And interest is also one point because simple and default both had been granted.
6%.
Yes.
And it will be 1/4 only.
He was working with the railways. The employer came and said that every month we deduct this amount from the salary. 200 for page 18, 18. This professional tax of 200 and
Was not
Permit, I have stated that it was not valid on the date of accident.
It is wrong. Yes. The learned advocate presenting the appellant insurance company submitted to apply the insolvency on the ground of false implication of the same since the complaint was lodged after 28 days of the occurrence of the accident. Being an afterthought have been maneuvered.
94.
The income
Exhibit
of
missing.
the victim was calculated exclusively on the ground of the income tax return filed, which had not been corroborated with any other document. Further, the permit issued in favor of the route permit issued in favor of the offending vehicle against the offending vehicle
Page 24.
was invalid. Was invalid. The learned advocate representing the respondent claimant submitted to have filed the cross objection on the ground that the learned tribunal, instead of granting 20% of the compensation to 20% as compensation towards the element of future prospect, 25 instead of granting 25% of the compensation towards the element of future prospect, had granted 20%, which had been erroneous, considering the age of the victim to have been 43 at the time of
accident,
the time of his death in the accident. ঠিক আছে? The document marked as Exhibit 1 being the complaint. Exhibit 1 being the complaint had delineated the reason for delay in filing the same owing to the time being consumed towards the medical treatment of the victim as well as taking care of the minor son, which had been acceptable and quite reasonable in the facts and circumstances of the case. Secondly, the income tax return to display the annual income of the victim is a legal document which cannot be negated or refuted. Question.
94.
Moreover, the appellant insurance company did not raise the issue of permit to have been invalid before the learned.
Apparently, it would seem the permit is invalid, but when we look into it properly, yes.
Well, kindly see
Page number 181. And the person who deposed on our behalf, this motor vehicle inspector DW1, he also came and he stated that the permit was valid. But if we look at the permit, page 32.
Page 32.
That is the evidence of DW1.
in the cross examine, it has been stated 32.
The evidence of
আমার এগুলো
Death of 12 years boy, not award pass. 155,000. 166 claim.
Yes, tell me.
Not jealous, brain of all this judgment of the order episode.
এটা কি নামটা বলুন?
Oh, yeah, tomorrow. But death of 12 years boy.
Death of 12 years boy.
My lord. Awarded or not, taking 15,000 per annum. 1,55,000 has been awarded. No interest has been granted.
One by one. What did you say? First ground?
But
What is your first ground?
first ground, lord, the income should be enhanced.
Huh?
Income should be taken 30,000 per month.
Income. His
Income.
first round is income. It should be 30,000 per annum as
What did the tribunal take?
Only 15,000 per annum.
When did the accident occur?
Option occurred the
2016. May 2016.
Yes, then
the interest has not been allowed.
interest not given.
Not yet.
Interest not given.
No.
Then
The honor appeals court, Lord.
third, next.
But these all, Lord.
Only this two. Chanchal,
Shall I calculate on the basis of 30,000?
30,000.
Ma'am. today. আচ্ছা, আমি minutes নিতে দিন।
এও শুরু করেছো?
This is a insurance appeal along with the cross objection of my learned friend. Milord, this on quantum. 2.5-year-old child, Milord, his right hand had been amputated. Milord, difficult case for me. But an award of Milord 20 lakhs plus was passed. Learned Tribunal Judge, Milord, on the basis of a disablement certificate, which considered this right hand amputation to be 95% permanently partial disabled, Milord. Milord, under the schedule, it is not that, and Milord, in any event, it is, Milord, to the maximum side, Milord, 95%, it cannot be. But still, Milord, 95% medical board had granted the permanent partial disablement certificate, and on that basis, Milord, 100% loss of income was considered. Monthly income of that little child, Milord, was considered at 4,800 rupees per month. On that basis, Milord, 40% future prospect was granted, and thereafter, whatever 100% loss of income was considered, 5.5 lakh, Milord, was granted under non-pecuniary heads. So in totality, Milord, if I wish to, Milord, indicate for every individual head, Milord, I shall be arguing the case. But in totality, Milord, this seems to be a little on the higher side. Milord, 4,500 per month income, 2.5. Father was a driver. His father was a driver. Milord, taking
Accident took place on?
Milord, 2022. And Milord, this 100% loss of income was considered. 5.5 lakh, Milord, was granted on this non-pecuniary heads in total.
Why did he file?
Milord, he filed for enhancement, whatever he can get.
Lordship, kindly, Lordship, is it 2 months, 6 years, whatever?
2 years, 6 months.
2 years, 6 months. Lordship, the learned tribunal considered the one judgment of the Supreme Court, Kajol. Just academically, I'm saying, by Kajol, and given the whatever the given by the Supreme Court in the judgment of Kajol Supra, the learned tribunal assesses the compensation accordingly. The learned tribunal come to a conclusion of 4,800. That is also appearing from the judgment of the Kajol. There is a 9-year-old girl. He lost his memory forever. So under such context, the Supreme Court has come to a conclusion. If he after attainment of majority, he would have earned rupees notional income as per minimum wages act 4,800. Lordship, I am not also going to the in one by one line. Lordship, kindly see that's the one hand.
Why have you filed the cross objection?
Cross objection, Lordship, I have filed. The learned tribunal ought to have granted the attendant charges and the attendant charges, and that has not been awarded by the learned tribunal. And also I have submitted that the nowadays, Lordship, the accident took in 2012. So Lordship, if at the time of attainment of majority is minimum.
A girl or a boy?
Boy.
Milord, as far as
medical expenses rupees 539.
539 because of they did not produce any papers in support of
he was treated in government
hospital. That is dealt with the learned tribunal. For the reason did not awarded any compensation.
Milord, as far as the Milord, there is. I'm sorry.
Both of you be contented with this? The medical
Expenses
expenditure is very less, and he has not taken this point. What is it?
Yes,
What is he saying?
I am
Milord,
saying
he was on convention, Milord, attendant charges.
Attendant charges, and have to consider the limb along with periodical charges of limb that I have. So Lordship, limb. So there is a one, yes, prosthesis.
Where is it? Have you?
No, because of Lordship is there, it can be presumed that one hand already been for already one time he has come. Lordship, apart from that, he cannot develop his figure, and he's also suffered the entire career. So is one hand already been amputated, boy, he will not cannot perpetuity cannot be going on. One time whatever Lordship will award, that will be the end. So 20 lakhs the awards are passed by the learned tribunal, And Lordship, there is a very low amount, it's a 50,000 only awarded for the future medical treatment. Even there is no evidence. And 539 as the medical cost.
So what can the tribunal do? You did
No. I'm admitting that I have not discussed with the issue. There is no treatment papers, but the government hospital treatment is there. I've admitted that.
Book note at page number 71.
71.
At page 71, Miller. Your Lordship will kindly say, Miller, at page 73.
Because of this, today is 3,300 per day, 9,000 2025.
Miller, if I can develop, I'm sorry. May I just, Your Lordship will kindly add one line, my lord. Entire compensation amount awarded by the tribunal
Ajay.
with interest is secured before my lord's court.
Judge.
Insurance company would deposit the further sum of 1.5
1
lakh.
lakh.
Lordship, kindly, my lord, add.
The entire sum of compensation awarded by the learned tribunal along with interest
Lordship.
at the rate of 6%.
Lord.
Bas, এবার ওই CRR.
Lord, tomorrow your lordship will take up, my lord, our claim application. So, my lord, this.
I just wanted to tell you one thing.
Lordship.
I don't know how many will be there tomorrow.
Yes.
For our list today, like 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 matters have been disposed. Right? So remaining 1, 2, 3, 4, 5, 6, 7, 8, 13, 14. So we'll take a jump tomorrow if we can dispose of 14 along with whatever will come today. Then we'll move on to applications. Let us first
Take care of the 4 orders.
because an application
Lordship.
can be but this 4 orders if we come to the regular
We will start with 4 orders tomorrow and then we shall see. Grateful to your lordship.
কোথায় referent date
309
আরে শ্রীমন্ত এসছে না না রেফারেল কাউকে ডাকো সিআরআর তো একদম না সেটা আমি বুঝতে পারছি অনেকটা বেশি হয়ে যাবে আচ্ছা শ্রীমন্ত কি এক্ষুনি গেল না না সেটা আমি বুঝতে পেরেছি কিন্তু কিন্তু
स्टार्ट किया वहां पे एंड करके
your matter is not being called, sir.
Sure, doctor.
309.
309.
309 is your matter.
No. 309 মানে I pay মানে this week so that I can communicate Devashish book.
ওই একই order 309 3010
Refer to
31
the refer to the মানে reconstitution.
310 310, anybody is there?
Yes, 308, that matter, one in one.
Sir, you please wait, your matters have not been called. 310, both parties. Huh. Oh, same. Same. Both parties. One
My
party.
lord, I am for the response.
Both of you are there. Acha, 313 both. You give your names. 314.
340, my lord, I am for the respondent. I talked with the appellant's lawyer, my lord. He told that.
So sir, please write your name and give it to him. You are for the insurance company?
I'm for the insurance company.
Respondent. You can respondent, please. Yes, 315.
315, my matter, I have given notice to the.
And what about insurance company?
I have given notice to the. Already given.
Okay.
notice.
Chalo.
Like today, your lordship will not be taken further for others matter. After finishing the.
Whatever you have done.
ফোন
ছিল
ওই নাম্বারগুলো আমি আছি
হ্যাঁ বলেছে তো
আসুন none appear to represent either of the parties. এটা কি কালকে ছিল? হ্যাঁ কালকে ছিল? Let the matter be adjourned for the day. Next.
My application, Lordship, by challenging the order dated 27th of March 2025 and 25th of the April 2025.
Will you please use the mic?
By challenging the order dated 27th of March 2025 and 25th of.
Which page?
Lordship, page number. Lordship, page number 38, Lordship. 38 and 39, Lordship. Lordship, whereby the opposite party filed 317 of CRPC application despite of the specific order dated, Lordship, 29th of 11, 2024. You can find it in page number 34, Lordship, where the judicial magistrate specifically directed to present in the court, Lordship. Despite of that order, Lordship, they are severally filed the application.
Which is the impugned order?
The impugned order you can find in 38 and 39, Lordship, where the OP number 2, Lordship, file a application under section 370, which has been allowed by the learned judicial magistrate 3rd court Chandanagar, Lordship. But on previous occasion, Lordship, on in order dated 29th of 11, 2024, Lordship, the judicial magistrate 3rd court, Lordship, specifically directed to the OP number 2, Lordship, that is the Shompa Shur, Lordship, to remain present in the court, Lordship. Even though in order dated 28th of February 2025 also directed to the said Shompa Shur to present in the court, Lordship. Despite of the both of the orders, Lordship, they are not present and filed the 317 application.
Here is the certified copy, Lordship, as
So this is for recording of evidence.
recording of evidence,
Then
Lordship.
what is your problem?
Lordship, there is a specific order, Lordship. I am led by Mr. Day, Lordship.
Valid on 28th of March, February, there is an order directing her, my lord, to appear personally. But kindly see
Directing her means whom?
by the opposite party number 2, my lord. Shompashur, my lord, kindly come to page number 35.
Sir, what is the issue?
My lord, despite direction, my lord, she did not appear, and thereafter on the 2 orders where, my lord, she prayed for time, and that was allowed. And against that order, my lord, I have come before your lordship.
She had,
Despite, my lord, the direction, she did not appear on the
which
next
direction?
occasions.
Which direction?
My lord, page number 35, order dated 28th February 2025.
Who had directed?
My lord, I have got it, my lord. First,
Whose direction was not complied
my
with?
lord, the order of the landed court below. The order, my lord, kindly come to the paragraph, my lord, first, second, third paragraph of page number 35. Landed APB files a petition praying for fixing consecutive dates for completing the formalities and evidence of PW1 as per the direction of the Honorable Court. He also filed another petition praying for securing the appearance of accused Shompashur, who is in opposite party number 2 hearing, as there was already direction to remain present, but she did not comply. Copy of these petitions are not served to the accused. However, as there is already standing order for her to appear, she is directed to comply the same and remain present
But
on the
then
next day.
the application under section 317 was allowed.
My lord, earlier, my lord, that was allowed. But this date, my lord, this is a direction. There is a direction. On the date of 28th February 2025, these are the direction passed by the landed court below. On the subsequent dates, page number 38, despite direction, my lord, she did not appear and 317 was allowed. But I have challenged these 2 orders. Page number 38.
Didn't you bring it to the notice of the judicial magistrate?
But that was despite, my lord,
Yes, it appears that the courts are different. Presiding officer was the same or different?
Manoj, on the date on 28th, the officer was judicial. Name is not written, my lord.
Because the JO code are different. The
Well,
JO
JO code on
code
third
in page
and
35 is WB101480, and that in page
it was a
38,
charge code, my lord.
it was a charge code, so it should have been brought to the notice of the charge court.
My lord, according to the instruction, my lord, it was brought, but my lord, despite that, my lord, this order was
Who will assess that?
but it has been continuing.
You have come against this.
Yeah, 2 orders, my lord. 27 March 2025 and 25th April 2025. These 2 orders.
27th
March 2025, page number 38, and my lord, the next page 39, 25th April 2025. These 2 orders.
No, Now, the 25th of April 2025 order was also passed by another
class.
judicial officer.
Yes, that's first class, my lord.
Then
This third court, my lord. Yes. My lord, subsequently, my lord, on 13th May, the same order is passed by the third court, my lord. This is a certified copy of the order. Well, this is a certified copy of the order because I was granted leave, my lord, to file a certified copy at the time of hearing, my lord. This is a certified copy.
but there was an opportunity granted to the opposite party number 2 to appear online for recording of evidence. Was that done?
No, my lord. Online facility was not there. Despite that, because of that, my lord, my client, the de facto complainant, also could not, my lord, depose because he is in, my lord, Finland. There is a prayer, and this honorable court was granted to appear virtually and for the evidence. Accused person are on several occasions, my lord, by filing the 370s without any documents, my lord. She did not appear, the opposite party number 2.
The learned advocate representing the petitioner submitted to have filed the instant revisional application, being aggrieved by the order dated 27/3/2025 and 25/4/2025, as well
Two orders, 27th March and 25th April.
27/3/2025 and 25/4/2025, passed by the learned judicial magistrate, third court at which
Third
place?
court at Chandanagar.
Chandanagar, Hooghly, in PS case number 112 of 2012, filed under section 341 by 323 by 465 by 471 by 506 IPC. The learned advocate representing the petitioner submitted that the OP number 2, being Shampa Shur, despite being directed to be present before the trial court by order dated
28th February 2025.
28th February 2025, did not appear before the learned judicial magistrate, before the court of the learned judicial magistrate, as aforesaid, for recording evidence.
Not recording, for its appearance, for her appearance.
For her
appearance.
Then what is this order?
My lord, page number 35, third paragraph. My lord. Third paragraph, there is already direction to remain present, but she did not comply.
Now, what will she do by being present if her, why do you need her presence? Her presence.
If she may flee away, my lord, there is a criminal case pending since long, my lord. It is a fraud, my lord, of 21 crore by forging her, the father's signature of the de facto complaint, my lord. The entire money siphoned away.
কি বললাম? However, filed applications under section 317 of the CRPC, which was granted time and again, disregarding the direction of the learned judicial magistrate, first third court, Chandanagar, Hooghly, as stated in order dated 28th of February 2025. The learned advocate representing the petitioner apprehends that the OP number 2 being accused of
under section 341, 323, 465,
accused
471,
under the aforesaid sections
341,
could flee from the jurisdiction of the trial court, which would hinder the progress of the proceedings pending before the trial court. The order dated 28/2/2025, 27/3/2025, as well as 25/4/2025 appear to have been passed by three distinct presiding officers in the class of in the third court of judicial magistrate, first class, Chandanagar, Hooghly. Whether the intent of the order dated 28/2/2025 was informed to the presiding officers on the subsequent dates could not be conspicuous from the orders dated 27/3/2025 as well as 25/4/2025. The learned judicial magistrate, first class, third court, Chandanagar, Hooghly, is therefore to who is presently presiding over the said court is to take note of the order dated 28/2/2025 and ensure the presence of the OP number 2 to facilitate the court in proceeding with the trial with further direction that the presence of the OP number 2 as and when required by the trial court should be strictly adhered to. The copy of this order be communicated to the learned APP, to the learned Court of Judicial Magistrate, Third Court, Chandanagar, Hooghly, as well as the learned APP.
Obligations.
এটা
One
কত
thing, my
নম্বর?
lord, year number may be mentioned, my lord, 619 of 2012.
CRR 2412 of 2025 is accordingly disposed of. আচ্ছা ওই যেখানে শুরুটা দেখুন যেখানে বললাম না ওই আন্ডার সেকশন ওই সেকশন গুলো যেখানে বলেছি হ্যাঁ IPC বললাম না 506 IPC in connection with GR case number
600.
because I have already mentioned the police case numberটা বলেছি না আগে হবে in connection with GR case number 619 of 2012. Next.
290.
না কত 291.
My lord, I am appearing through virtual mode, 291, 292 and 293. My lord, three matters are together, which will be dealt with by the same judgment, by dint of same judgment. My lord, in 291, I am placing.
91, 292, and 293.
My lords.
Yes, what is it?
My lord, this is a case of quashing of an FIR. My lord, kindly sees the letter of complaint. The entire thing will be clear. The sections which were in.
Which page?
My lord, the certified copy. The certified copy. I cannot number the certified copy, my lord, because it will amount to tampering. The last portion, my lord. The letter of complaint, my lord.
Yes, it is 28th of April 2024.
My lords, my lords. My lord, my humble submission is this, that no.
Let me go through the complaint first.
My.
Yes, what happened?
My lord, the alleged incidents took place in Pornosri Police Station jurisdiction, but FIR was registered by Newtown Police Station. My lord, my first stroke of challenge is the jurisdictional error. The Pornosri, if at all, the complaint is taken on its face value, then it has to be registered at Pornosri Police Station, but it was registered at Newtown Police Station. Secondly, my lord, there is no dishonest intention. My lord, whatever money has been invested by the party, that he has invested consciously, and there was an agreement. So, my lord, specific relief act will prevail. They have to go for a civil remedy. But what they have done, they have filed an FIR so that by giving a criminal color, they can extort the money or take back the money. My lord, there is no iota of allegation in the impugned FIR that I have concocted any government record or any type of document by which 467 section has been invoked. My lord, the second is, my lord, I cite the judgment laid down in state of Haryana versus Bhajanlal in 1992, SCC 335, wherein Supreme Court held if the allegation do not disclose cognizable offense, FIR is liable to be quashed. My lord, my humble submission is that FIR contains omnibus allegations, my lord, without any specific instance. There is no specific instance has been given. My lord, of forgery of a document or valuable security. No forged document is produced or referred to, my lord. Thus, section 467, 468, and 471 are mechanically invoked. My lord.
The learned advocate representing the contentious are similar in the other two.
My lords, my lords.
The learned advocate representing the petitioner appeared online and submitted to have filed the instant revisional application for quashing. You have of the FIR.
FIR, my lords.
Quashing of the FIR drawn in connection with Newtown Police Station case number
110 of 2024, my lords.
Of 20.
And second one is, my lord, 380 of 2023.
পাঠ করো মোবাইলটা নিয়ে নিক তখন
মোবাইল ব্যবহার করছে
ওই পুলিশকে দিয়ে দিন
My lord, second FIR is 380 of 2023, my lords.
PS case number 110 dated 28/4/2024, filed under section 480 by 406 by 467 by 468 by 471 by 120B by 34 of the Indian Penal Code. The learned advocate representing the petitioner further submitted that the complaint was lodged within the lodged at the New Town Police Station instead of Pornosri Police Station, giving rise to an anomaly in the point of jurisdiction. It was further submitted that the complaint itself did not delineate any cognizable offense to have committed in accordance to the elements of the offenses under which the FIR was instituted as stated above, relying on the decision of the Honorable Supreme Court in Bhajan Lal's case. Full stop. The contentions of the learned advocate representing the petitioner are required to be assessed on the basis of the submissions basis of the submission of the learned advocate representing the state as far as the case diary is concerned, revealing the status of the complaint. Notice to be served upon the learned advocate representing the state as well as the opposite parties, intimating the next date of hearing. Affidavit of service to be filed to that effect. Next date.
My lord, I pray for stay, my lord. There is an addendum stay prayer also, my lord.
Next date be fixed on 31st of October. When was this filed?
My lord, it was filed, my lord.
28th of April 2024.
My lord. My lord, I pray for a limited stay, my lord. Kindly, my lord, because anticipatory bail has been granted, my lord, and my lord.
When you have been granted anticipatory bail, so enjoy that. Next date.
My lord, kindly consider, my lord. My lord, this is a puja also come, my lord. In the meantime, they are harassing him. Nothing else, my lord. My lord, kindly.
Have harassed you during last pujas. They will not harass you now also. It's of the complaint is of 28/4/2024. In between last year, you had the puja and you enjoyed the puja.
My lord, then kindly keeps it under the motion heading so that it can reach, my lord.
In any case, it will be placed before the regular bench.
My lord, I have no issues, but adjourn motion or under the appropriate heading so that it can be taken
Under
up.
the
Because
appropriate
stay is,
heading. Under the appropriate heading.
because
Now,
stay is.
আচ্ছা ওখানে ওই নম্বরগুলো বদলে যাবে. The police station case numbers will be
different,
right?
Different, my lord. 292 te different, 293 তেও different, my lord. বাকিগুলো same, my lord.
আমি ওকে বললাম ও আমাকে বাংলা. Next.
Grateful, man.
294
In item number 294 or 95, I am appearing in behalf of petitioner, my lord. My lord, I am praying for not this week Mr. Tiwari appearing in this matter. He is out
Which
of
Tiwari?
time. Mr. Moti Sagar Tiwari. He is appearing. One of his family member has expired, my lord. I am praying for not this week.
Who are you?
I am junior.
It seems you don't have any urgency, so it's better that you place some matter before the regular bench. The learned advocate representing the petitioner submits to have been the junior of the advocate on record,
No. Yes, madam.
of the learned advocate on record. Let the matter be placed before the regular bench. 294, 295. Huh, Pepper? None appeared to represent either of the parties. Let the matter be adjourned for the day. বেকার আমাদের লিস্টটা বেড়ে যাবে। None appeared to represent either of the parties. Let the matter be adjourned for the day. Next.
298. This is for the extension of history. The whole time I have filed it and start the copy of that this is the
Had filed a CRAN application.
Yes.
So it's not on record. CRAN application for extension.
Yes. I have a copy.
No, the department is directed to place records of the CRAN application being
One. 10-1.
1 of
2025.
2025 on 8th of September.
8th of September.
Let the matter be fixed on 8th of September. Next.
399. 299.
Lordship, in this matter, I am appearing on behalf of the petitioner, Lordship.
Yes, what is it?
Lordship, this application has been filed for quashing the FIR, which has been placed against the petitioner number 124 before the Bardhaman PS, case number 114 of 2024. Lordship, it is the charges made under section 323, 325, 307, 506 and 509 of IPC, along with section 3 and 4 of Dowry Prohibition Act.
Yes.
Lordship, I have served the copy to the state as well as the opposite party number 2, Lordship. Lordship, there is an interim prayer for stay upon the proceeding, which is the date on the trial court is fixed on 9th of September, Lordship.
9th of September for what?
For personal appearance, Lordship. Petitioner number 4, Lordship, staying outside of India, Lordship. It is difficult for her because she is now having some medical issues as well. Therefore, she is unable to travel so far in India, Lordship.
Which is the order that you are challenging?
Lordship. Lordship, I am challenging the entire FIR, Lordship.
The learned advocate representing the petitioner is to serve notice upon the opposite parties intimating the next date of hearing and file an affidavit of service to that effect. Next date we fixed on 10th of September. Next.
Lordship.
300.
My lord, I'm praying for only short passover, my lord. Learned advocate on record is engaged in another court, my lord. Only short passover, my lord.
Next.
101.
Speak, my lord. I'm praying for not today, my lord.
Let the matter be placed before the regular bench. Next. None appeared for either of the parties. Next.
302.
Three hundred and two.
Hmm.
None appeared to represent either of the parties. Let the matter be adjourned for the day. Yes.
303.
This is challenging domestic violence proceedings. So that 2011, the wife leaves the house. The husband expires in 2020. She files a there to contest. Thereafter, 19, after 8 years, she files this complaint under the Domestic Violence Act in Calcutta
Against?
against the parental laws and the husband. The husband later expired. Like he expired in 2020 after the filing of the case. We filed an application challenging the very maintainability of the said proceeding. That was turned off. We preferred an appeal. That was also turned off. We are after 8 years, not even explaining as to how domestic relationship happened for all these years. Because admittedly, in the matchbook, she says that she had left the matrimonial house in 2011. And thereafter, there was no. There was the.
When was the match suit filed?
Match suit was in 2014. In 2014. The match suit we could not get the certified copy, so we could not annex it. We have applied for. Lordship allows us to serve and then come back, my lord. We'll, in the meantime, we'll arrange all this.
For the submission of learned advocate representing the petitioner, it was submitted that the opposite party wife
Yes.
had filed a suit for dissolution of marriage in the court of
For the action is her admitted position at page 32, Malad.
32.
Yes. In her section 12 application, she says about the matrimonial suit, Malad. Subsequently, your petitioner, the wife, filed a matrimonial suit before the district judge at Alipur. While match suit number
32.
one.
There are two numbers.
Running page 32, Malad. I am sorry, Malad.
There are two numbers, 30 and.
Malad, the application starts at page 21 in my brief, if your lordship. Malad, may I just find it out for your lordship? Ma'am, may I just find it out for your lordship? I'll find it out for your lordship.
There are two numbers.
Malad, maybe, Malad, the certified copy annexure P1 starts from page 27. The last paragraph. The last paragraph.
Being match suit number 1 of 2014 at the Court of District Judge at Alipur, which was thereafter transferred to the Court of Learned 8th Additional District Judge at Alipur. It was further submitted that the aforesaid matrimonial suit is still pending for adjudication. The
Since the
learned
husband has died,
advocate
my lord, so
represented petitioners submitted the maintainability of the instant complaint
instant proceedings
instituted under section 12 of the PWDV Act is to serve notice upon the opposite parties intimating the next set of hearing and file an affidavit of service to that effect. Next date be fixed on 19th of September.
My lord, only prayer is, my lord, the parents, the petitioners before lordship, both are senior citizens and residing at Haryana, my lord. If their personal attendance in the DV court can be exempted for the moment.
Personal appearance in the?
Before the learned magistrates court for the moment may be exempted. They'll be represented by lawyers, my lord.
Which date is it? Next date has been the personal appearance of the petitioner number.
Both the, my lord. Father and mother are the petitioners before lordship.
Personal appearance of both the petitioners.
No, my lord, there are 4 petitioners. Brother also, he is also resident of Haryana.
And what about the parents? Petitioner number
1 and 2.
1 and 2.
Both are 72 years old.
Is exempted. The learned trial court will seek the attendance of the learned advocate representing petitioner number 1 and 2 before the same without fail on each and every date. Except on occasions for recording evidence.
If at all, my lord, it's only
If at all required.
If at all, because it's only in the preliminary stage.
It cannot be infinitely given. So, as and when there,
As and when required.
not on a regular basis. Next.
Only one line be added. Liberty to mention after service, my lord. Since there's no stay, I will have the liberty to mention the matter after service.
Liberty is granted to mention after
the service
of the notice upon the opposite parties. In any case, till 26th.
Yes. So we'll have to effect service on them. We have to get it heard, my lord. Otherwise.
Lordship, item 300, Lordship, passed over matter, Lordship.
What?
Item 300, Lordship.
You simply can't barge in, madam. 303.
No, I'm for the petitioner, my lord. I'm for the petitioner. A very small prayer, my lord, for expeditious disposal, my lord.
What expeditious disposal?
Case is initiated on 2012, my lord. Subsequently, my lord, after 2 months, charge sheet has been given. Till today, my lord, only out of 7 witnesses, my lord, only 2 witnesses has been examined. After 13 years, my lord.
After?
13 years. This is current 13 years, my lord. Total 7 witnesses, my lord. Only 2 witnesses has been examined.
The learned advocate representing the petitioner submitted that out of
7 witnesses,
2 witnesses had been examined in connection with GR case number 4164 of 2012 pending in the court of Judicial Magistrate, First Court, Howrah. Full stop. Evidently, 13 years have passed from the date of the first order being?
First order being, my lord, 29. Is my lord.
7/7/2012. 7/7/2012. The learned Judicial Magistrate, First Court, Howrah, is to take necessary steps in concluding recording of the evidence of the remaining.
It's 6 months or 12.
Remaining, how many witnesses?
5.
Remaining 5 witnesses as expeditiously as possible without granting any adjournment to either of the parties, preferably within a period of 8 months. The CRR 2437 of 2025 is accordingly disposed of. Next.
Next.
Lordship, I beg to appear on behalf of the petitioner.
Yes, who is appearing for the state?
In spite of service, nobody is appearing. As directed by your lordship, in sitting in the vacation bench, there was a direction. Pursuant to that, I have served. And here is a
Thereafter, but the next, it was to appear on the second week of July.
it has appeared, but it came in the monthly list.
So what do you want?
Lordship, I want the stay of the proceeding.
No, but then you serve a fresh notice upon the state.
I am serving. Mr. Mukherjee is there in the other side. I know. Mr. Rana Mukherjee.
Sir, you
No,
are
Lordship,
learned advocate representing the petitioner is to serve fresh notice upon the state, opposite party state. And who are the other opposite?
None.
Opposite, only state.
Only state.
Opposite party state, intimating the next date of hearing to be present before this court along with the case ready.
Allot.
Next date be fixed on 19th of 22nd of September.
Grateful, Lordship.
Next.
Lordship, actually 23rd, there is a date in the learned code below.
So I have kept it on 22nd.
Lordship.
Next.
Same order, Lordship. Actually, both husband and wife has been arrested in this case.
Okay, so the same order. 22nd September.
In 306, I'm for the state, Your Lordship.
You are for the state? Show me your engagement letter.
Not engagement. Printer, we need to print it out, Your Lordship.
Print it out on the next date and come. Next.
Grateful.
May it please your ladyship, I'm appearing on behalf of the petitioners. I apologize for conducting this hearing online, your ladyship. I'm stuck in a flood situation in the northern part of India, unfortunately.
You are not on your robes even.
Yes, my
You are not on your
ladyship.
robes, but it seems
Just
to
coming
be
out
in a
of court.
car.
It's been totally wet. My ladyship is all around me. I'm just stuck. I really apologize at the very outset. It's a very, very bad condition, unfortunately, in Chandigarh today.
That doesn't prevent you from appearing before the court on robes, sir.
Ma'am, it just because I was humbly apologizing because while coming, we had a small accident and the road got really wet. I really apologize. Unconditional apology, my lords. Your leadership, if I may
You're
submit,
the
this is
advocate on record.
Smith Goham appearing. He's briefing me, your leadership.
You ask your advocate on record to be present.
You're supposed, I think he's also stuck somewhere. He just messaged me, stuck somewhere.
Okay, so you people better be stuck.
So he asked me, processing the petition in this. Really, if I just, it's
The
a very
matter-
peculiar small case.
Let the matter be placed before the regular bench.
My lord, it's a very one small point, my lord. If you can just give me 2 minutes to
Sir,
explain my
this
point.
kind of conduct, I believe, the manner in which you are approaching the court will not be acceptable
My
to
lord,
any. Right, sir?
no, my lord, I humbly apologize. It's a flood situation here. Can I just get 2 minutes, ladyship? I beseech your ladyship. It's a very peculiar matter.
You appear tomorrow then in proper form.
I will, my ladyship. You can just,
Let
if
the
it
matter
can
be
be done
adjourned
tomorrow.
for the day.
I'm so grateful and I apologize, grateful. I'm so sorry, ladyship.
I am
Yes,
asking for
sir.
the petitioner. The DW order of the DW, the last page, page 70. Page 70. Page 70.
Sir, is it 7070 or 1717?
70. 70. Order dated 17 May 2005. The 2025. But order of distress warrant was DW was issued.
You have paginated till 67, 69.
70.
It's is the certified copy.
Certificate copy.
Yes, which is the date of the order?
17th May.
17th May. Yes, today is fixed for payment of rupees 36,000.
Samladi, it was fixed for DW. And next date, 25th June 2025.
Right.
2000. On that day, I have challenged this order because at the relevant point from the initiation of the proceedings, fact is this, the marriage was solemnized in the year 2014.
Right.
The wife left her husband in-law house due to reason of his service as a teacher.
Sir, you better pay the 36,000.
Lordship, kindly allow me to place.
I have seen the order, sir. Time and again you had been asked to pay the.
Lordship, kindly allow me to. So next day tomorrow, kindly come tomorrow.
Tomorrow will not change my opinion, sir.
It may be,
You
but
have to pay, otherwise you face the consequence.
no, what am I submitting?
Yes.
The warrant has been issued.
Let the warrant be executed, sir, because you had been granted sufficient time to pay the 36,000 rupees.
Look, if your lordship kindly allow me, then whatever it will be the order.
Tell me.
The fact is this: the marriage was formalized in the year 2014.
2014.
14.
Right.
Now, after 24 days, she left her in-law house. এটা আমি মনে হয় ভুল নিয়েছি। She left her in-law house. আমার নোটটা কোথায় গেল?
He left in. Then what happened?
Left her in-law house. Then Lord, in-law house on the ground. He is a teacher nearest to his parents' house. She has been rendering his service there. Blood in the year 2024, on 24, the 18th July 2024, the husband left India. For long 10 years, both are separate.
Right.
He left India, went to the USA due to look after his only brother who is alone there, who has a cancer patient, to look after him. And thereafter, his brother was expired on 19 January 2025.
Right.
He returned 27 January 2025. In the meantime, Lord, fact is this. In the meantime, Lord, 26/12/2014. 26 December 24, the interim order was passed. Then the petitioner came back after everything complete. After every execution proceedings started, DW issued, come and file application under section 125(4) and 125, stating inter alia reason that the maintenance is not maintainable. That application is pending. Despite of that, on that relevant date.
Now, have you challenged this order?
Yes, that is the subject matter of challenge. Then, Lord, on 25th May 2, if your lordship, in the meantime, I made a supplementary evidence. May I please? Lord, kindly see page 10. Supplementary list, 17th May 2000, supplementary list.
Yes.
Lord, the 25th June 2025. June 6. June 2025. 2. But on the relevant date, when the learned advocate of the husband went there, he found that in the record, the order is passed DW, same order, DW. Then another order is passed without sign. That first order is cross. Second order is without sign of the learned court. Then he submit before this court what is the reason. Learned court stated that yes, I issue today a warrant. That is why this application is supplementary rapid is filed. Now the fact is this: if your lordship kindly call for the record, the entire matter will be crystal clear before your lordship.
Sir, order dated 26/12/2024.
Lordship.
Right? Today is fixed for hearing. Both party files Hajira. So both the parties were represented.
But if your lordship kindly see the ticket of the plane, I was abroad. Husband was abroad. Who appeared? That is collusion. That is my allegation. Who abroad? Kindly see the plane.
So you are denying the marriage?
No.
If you're not denying
No,
the marriage, sir,
that-
first pay the amount and then come.
No, not the divorce application is filed on the ground.
Fair enough, sir. You pay for the maintenance that has to be paid and then come. Otherwise, I will not interfere with the order.
In fact, just useless.
Useless.
Useless because 125, right, for a moment, 125(4) is pending. I did not get the chance. Violation of natural justice. I did not get to submit. Well, kindly call for the record and allow me to.
First of all, you have to pay that amount, sir.
He deserted. That is running.
Who is deserted? Who has deserted?
Deserted, left. Sorry.
Left.
Why? Last 10 years, there is no whispering. Last 10 years, I have stated everything. That is why I am submitting for this. Last 10 years, 2020, 2014, marriage was solemnized. 24 days was stayed in the.
When is the next date fixed for?
24th September. 24th September.
24th September. Is the date fixed for?
Warrant.
Warrant. Where is it? Where is the copy?
Lord, the supplementary affidavit, page 11. Inter matter, my lord, collusion. That is why.
Yes.
If your lordship kindly call for the record, it will be crystal clear what is happening there.
Very
What
good.
is happening there?
Very good. What about the? Did you file any? Did you?
125, 4 and 5 I have.
But then against this order, you have not taken any steps in the upper forum. Against the order dated 26/12/2024, did you file any revision?
Yes, this is the. No.
You have not. Right. The learned advocate representing the petitioner submitted that the opposite party wife had deserted the petitioner 10 years back after a limited period.
Sorry, left, not deserted. Sorry, left.
But you were stating deserted, sir?
Sorry, wrongly.
Wrongly. Had left the association of the husband after a limited number of days cohabitation at her
24 days.
24 days of cohabitation at the matrimonial house. The opposite party wife had filed an application under section 125 of the CRPC, which was registered as M case number 425 24 in the Court of Judicial Magistrate, 5th Court, Barrackpur, non 24
Suspended in charge.
Parganas.
Order passed by the judge.
In the 5th Court, Barrackpur, notes 24 Parganas, and wide order dated 26/12/2024, after hearing both the parties, the Learned Judicial Magistrate, 5th Court, Barrackpur, not 24 Parganas, had inter alia directed the opposite party husband to pay an interim maintenance of rupees 12,000 per month for the period to the wife, being the opposite party hearing, till the disposal of the aforesaid M case. It was further directed the interim maintenance for a particular month shall be paid within 10th of next corresponding English calendar month. The order shall take effect from the date of filing of the aforesaid M case. The payment, if any, that the opposite party, being the husband, to have made during pendency of the aforesaid M case to the wife, should be adjusted after production of proper receipts and on verification at the time of calculating arrear maintenance. Next date was fixed on 7th of November 2025 for evidence. The petitioner hearing, being the opposite party husband in the aforesaid M case, did not comply with the order dated 26th of December 2024. Till date. By order dated 17th of May 2025, the aforesaid judicial magistrate, by order dated 21st of April 2025, the aforesaid learned judicial magistrate recorded that 21st of April 2025 was fixed for payment. However, the opposite party husband did not take any steps. Did not take any steps. Next date was fixed on 17/5/2025 for payment of rupees 36,000. Full stop. On 17th of May 2025, though the learned advocates representing both the parties had filed hajiras, however, the opposite party husband did not pay the amount of rupees 36,000 in compliance with the order passed by the learned judicial magistrate as aforesaid on earlier occasions. Hence, directed for issuance of DW against the opposite party. Next date was fixed on 25th of June 2025 for ER of DAW.
But there is no order. Immediate thereafter, Lordship kindly, if your Lordship kindly consider, kindly see page 10 of my supplementary affidavit.
Next date, as per the document filed in the supplementary affidavit on behalf of the petitioner applicant herein, by order dated 28/8/2025 in the aforesaid in MV case number 07 of 2025, 24th of September 2025 was further fixed for ER of WA, ER and WA. The learned advocate representing the petitioner submitted that an application under section 124(5) subsection 4 and section 125 subsection 5 are still pending before the learned trial court, and further submitted that the pendency of such application did not call for the compliance of the order dated 26/12/2024 for payment of the interim maintenance by the petitioner husband as stated therein. The learned advocate representing the petitioner husband had paid for an interim order of stay of all further proceedings in connection with M execution case number 07 of 2025 arising out of M 4425 of 2024 filed by the opposite party number 1 wife pending before the court of learned judicial magistrate 5th court Barrackport North 24 Parganas. The petitioner husband has to comply with the order dated 17/5/2025 passed by the aforesaid Court of Learned Judicial Magistrate within 10th of September 2025, failing which the trial court as aforesaid should proceed to direct the concerned authorities to expedite the process of execution, process of ER and WA. Next date be fixed on 11th of September for filing the report by the learned advocate representing the petitioner husband as to whether the order passed by this court has been complied or not. Next date be fixed on 11th of September. Nothing doing, sir. You have not disputed the marriage.
Last 10 years, she was not with me, with the husband. She left.
That has to be decided at the final hearing. আচ্ছা ওখানে লিখে দিন আগে আগে এটা the order dated দেখি ওইটা, না না ওইটা 26 the order dated 26/12/2024 did not reveal the opposite party husband to have denied the marriage with the petitioner. Moreover, the learned judicial magistrate had passed the interim order on the basis of the declaration of assets as mentioned therein. Sir, till you have the next date is on 25th. I have given you sufficient time. By 10th, you deposit 36,000 and then come file the report. Then we'll see.
36,000.
36,000. First of all, to the 17th of May, that order. That has been mentioned. That has been mentioned. You cannot be so obstinate and you cannot, act. You should not comply. Then why didn't you file a revision?
That is the
Then
fault on the part of the husband.
fault on the part of the husband, then the husband will pay the money. Next. Next. You will go to America, you will do everything and you won't pay money. Yes, what is it?
Lordship, I am for the petitioner. Lordship, I have to file the affidavit of service.
Sorry?
The state respondent, Lordship, I have to file the affidavit of service, Lordship.
So that was long time back. So you serve afresh and then come.
Not long time, Lordship.
Yes,
Then it is on
22nd of July.
Yes, Lordship. Today also I sent my clerk for knowing the learned advocate who is engaged in the matter, but Lordship, the PP office refused to inform the advocate's name, Lordship. So that I can inform, I send my clerk, Lordship.
So, sir,
But
that
of it-
exercise, madam, I can't do for
Lordship,
you.
only
You
Lordship,
have to get it done yourself.
Lordship, only to indicate that I have to serve the notice to the PP office. And
Yes.
tomorrow that matter to be fixed, Lordship.
What is it?
Lordship, the petitioner made application under section 175(3), Lordship, under BNSS Act for registering his complaint as an FIR, Lordship, and to investigate into the matter, Lordship. The wife of the petitioner gave him poison in rice, Lordship. The
The
complaint
learned
had not.
advocate representing the petitioner has filed the affidavit of service. Let the same be kept on record. However, none appear to represent the state. The learned advocate representing the petitioner is to serve a fresh notice upon the learned advocate at the office of the
PP office.
government pleader and public prosecutor, intimating the next date of hearing, so that the state will be appropriately represented. Let the matter be fixed on 8th of September. এটা কত নম্বর ছিল? এটা 308 আছে না? ওটা হয়ে গেল? এটা কত? 300 ছিল? আবার কি? আজকে আমাদের কথা ছিল এতে 25টা।